Did you have any trouble getting into the job?
Oh,
You're in job?
the little stuff, yeah. I don't know, it's right here. It's the only PSC job that I know, unless it's the commissioners. Find out what job it is, or you don't know. Okay, if it's 94.99, I've got it.
Doug?
Yes, I'm here.
Okay, good. Just making sure.
You're coming through loud and clear. Thank you very much.
Thank you.
Checking, checking, checking. One, two, one, two. Test, test, test. Checking. Checking. One, two, one, two. Okay, test. Test of 1, 2, 3. 5, 4, 3, 2, 1. Checking. 1, 2, 1, 2.
Good morning there. I'm just checking the audio on my end.
Oh, good idea. Can you hear me as well? This is Kenny Albert.
Yes, Mr. Alpert, I could hear you just fine.
Thank you.
Yes, this is Doug. Yeah, I didn't get on until 10 minutes before. I'm on there now. It hasn't started. Well, wait a minute. Is this PSC 94.99 or is this PSC with the commissions?
This is 94.99.
I'm
Hi,
on.
everybody.
Okay. All right, thanks. Bye-bye.
Just a quick audio check. Are you able to hear me, Fred, or anybody else?
I hear you. You sound good. So
Okay, all right, thanks.
This is Kenny again. I just plugged in my mic. Can you hear me on the mic?
Hear you?
Thank you.
Checking 1, 2. Checking 1, 2. Checking 1, 2. This is 94.99. 11/8/21, 10 a.m. Organic Road Solar. Hearing.
Are you ready to go on the record, Mr. Court Reporter?
I'm ready, Your Honor. Can you hear me okay?
Yes, thank you. Good morning. This is the Public Service Commission's evidentiary hearing in case number 9499, which is captioned in the matter of the application of Morgnec Road Solar LLC for a certificate of public convenience and necessity to construct a 45 megawatt solar photovoltaic generating facility in Kent County, Maryland. We will start with appearances. Counsel for the applicant.
Morning, Your Honor. David Bugelman's on behalf of the applicant. I'd also like to enter the appearance of Mr. Todd Chasen as co-counsel. Morning.
Good morning. And PPRP. Ms.
I'm
McLemore.
sorry, I could not hear you. Good morning, Your Honor. Sandra McLemore on behalf of the Power Plant Research Program. Also today I have with me Mr. Steve Towson, who as co-counsel. Thank you.
Thank you. Kent County Preservation.
Did it?
Morning, Your Honor. Christopher Drummond, representing Kent Conservation and Preservation Alliance.
Good morning. Kent County.
Yeager, County Attorney representing Kent County. And I'm in the planning office with Planning Director William Mackey.
Good morning.
Morning, Your Honor.
The town of Chestertown.
Jesse Hicks on behalf of the town.
Mr. Hicks, you're a little faint.
Good morning, Your Honor. Jesse Hicks on behalf of the town of Chestertown. I'm going to try to work on that. I had some issues.
Okay. Great. Good morning to you. Office of People's Counsel.
Good morning, Your Honor. Frederick Hoover on behalf of the Office of People's Counsel.
Good morning. And staff of the Public Service Commission.
Good morning, Your Honor. Kenneth Albert, along with Annette Garofalo for Commission staff.
Good morning. Okay. Everyone should try to remain on mute until it's your turn to speak, just so that we don't get any feedback. This is being recorded and also live streamed to YouTube. We have some housekeeping matters. Let's start with the most pressing one. Ms. McLemore, I understand one of your witnesses is ill.
Yes, Your Honor. Yes, Your Honor. We don't know anything further right now, but I will keep you apprised as I learn anything new.
Okay, because I didn't know if there was, if you had spoken to Mr. Bugelman's about perhaps, going out of order, if that would help, or whether PPRP is going to have another witness to substitute in.
Yes, Your Honor, we're trying to find that out right now. This just happened this morning, and so we were kind of caught off guard on that, but we're trying to find out, and I will let you know as soon as I can. Currently, let's just try to go as it is right now, and when PPRP is called to the stand, I will let you know if I need to do anything at that time differently. I don't really know what else to do at this time.
All right. If you need to let me know sooner, though, so we can rearrange the schedule, if that helps, please let me know. We will start, as we did today, at 10 a.m. tomorrow and Wednesday. We're not here on Thursday because it's a state holiday. We will take a break for lunch of approximately 30 to 40 minutes, around 12:30, but it will depend on where we are in witness testimony. Take a short afternoon break and try to finish up every day by 5. We need to be done at noon on Friday. I would hope actually we can finish on Wednesday, but if for some reason we're still not done by noon on Friday, the Public Utility Law Judge calendar does have Monday available. If people want to check their calendars, we could see at the end of the day how things are going. Are there any other housekeeping matters before I move on to the ground rules for today?
Your Honor, I do have one question. If possible, if people could let me know if they have questions for Mr. Hall, cross-examination, and about how much time it is, that might be helpful in trying to make sure he could make it through, or if, you know, if it's something we could do right now.
Okay, as a courtesy, if council could let Ms. McLemore know about how much time they think they would have for Dr.
This
Hall.
is Chris Drummond. I certainly have questions for Mr. Hall. I would guess it would be on the order of 30 minutes or less.
I guess Kent County or the town of Chestertown?
If this is Tom Yeager, Kent County, if I do have any questions, they would be minimal. So I don't think I need any significant amount of time.
Tom, this is a court reporter. You're gonna have to speak up louder because I'm not picking you up very well.
Sure. This is Tom Yeager, the Kent County attorney.
Do you have your video on, Mr. Yeager?
Yes, I can see myself.
Oh,
I'm under William Mackey, and that's another question I have. I saw the directive that said that attorneys were not to be present with witnesses.
correct.
How is that to be interpreted? Because Mr. Mackey is my client, is the county's representative as the planning commission. Is that interpreted as only that Mr. Mackey cannot be in my presence during the time Mr. Mackey's testifying? Or is this order interpreted as meaning Mr. Mackey and I have to be in separate rooms? If it's interpreted that we have to be in separate rooms for the whole hearing, I would respectfully object, because I believe that my client is entitled to have a representative here at all times. Mr. Mackey would be the appropriate representative given the nature of the case.
Understood. I'm going to pull it up just so I okay, my interpretation is that the witness, when they are testifying, needs to be in a separate room.
That would be acceptable.
I'm not going to require the witness be in a separate room when they're not testifying. Does anyone have a problem with that? Okay. And that brings me to another point. At different times when people are going to be introducing evidence, if you don't have an objection, you don't need to say so. It takes up more time to unmute and say no objection. But if you so only plan to unmute and indicate when you do have an objection. Okay, I will pause and give time for people to object, but otherwise stay on mute. That goes for witnesses and counsel. So the order of witnesses, other than if we have to rearrange due to the illness of Dr. Hall, we'll start with applicant and applicants, I believe 13 witnesses, followed by PPRP's 2 witnesses if possible. OPC, do you intend to participate and cross-examine witnesses today? Or any
We
of the
may
days of the
have
hearing?
some questions for a couple of the witnesses, but nothing extensive.
Okay. OPC is, of course, welcome to participate. However, not having filed anything, as I'm sure you know, Mr. Hoover, friendly cross is not allowed.
I understand that. So.
Okay. All right. Kent County Preservation will then go next.
Sorry.
And the order is the order in which motions to intervene were filed, if there's any question there, followed by Kent County and then Chestertown. Lastly, as is often the case in our proceedings, staff will go last. That's the same order that will be used on cross-examination. Does that make sense? So now witnesses on cross-examination are permitted to clarify a yes or no response to the extent necessary, but there's extensive written testimony filed in this case, and I have reviewed it all at least once, if not twice. So there's no need to go beyond a clarification to reiterate portions of written testimony, and I will entertain objections if that does happen. When we're finished with cross-examination, counsel for the party will have the opportunity for a redirect. And then I may or may not have questions for the witness. If I have questions, counsel will have the opportunity to ask questions based on my questions only. Okay, does anyone have any questions? Okay, Mr. Bugelmans.
Yes, Your Honor. So before we call our first witness, Your Honor, we have about 12.5 exhibits, miscellaneous exhibits that we need to mark and enter at the start.
Okay, and I do thank you. I appreciate getting the exhibit list. It makes things much more efficient. And as you've noted on the list, 1 and 2 were already admitted into the record at the pre-hearing conference. So wherever you start, you'll be on number 3.
Thank you, Your Honor. Just for clarification, were we calling them applicant exhibit or Morgnec? It's been a few years, so just
Let
want
me
to make
pull
sure
up.
we're consistent.
Yeah, what I'll do is pull up the transcript from the pre-hearing.
Okay.
And then I can tell you what we called them. You called them applicant exhibit 1 and applicant exhibit 2.
Thank you, Your Honor. Okay, so the first new exhibit, Your Honor, would be the CPCN petition, which was filed on November 30th, 2018. That consists of 11 pages under mail log number 223101.
The petition will be marked as applicant exhibit 3.
Thank you, Your Honor. Next, we have the environmental review document and appendices that was also filed on November 30th, 2018. That consists of 182 pages, also under mail log number 223101.
That'll be marked as applicant exhibit 4.
Thank you, Your Honor. Next, we would like to mark for identification the applicant's, as applicant exhibit 5, the applicant's first response to the POJ's notice of completeness determination that was filed on January 17th, 2019, consisting of 6 pages under mail log number 223656.
That'll be marked as applicant exhibit 5.
Thank you, Your Honor. Next is applicant exhibit 6. We would like to mark the applicant's second response to the PLJ's notice of completeness determination, which is filed on February 28th, 2019. That consists of 54 pages under mail log number 224137.
So marked.
Thank you, Your Honor. Next, we have the online notices compliance filing for the first public comment hearing, which is filed on April 23rd, 2019, consisting of 5 pages under mail log number 224897.
Marked as applicant number 7.
Thank you, Your Honor. Next is applicant exhibit 8. We have the print notice compliance filing for the first public comment hearing, which is filed on April 24th, 2019, consisting of 3 pages under mail log number 224904.
Marked as applicant exhibit 8.
Thank you, Your Honor. Next, as applicant exhibit 9, we have the signed compliance filing for the first public comment hearing, which is filed on April 25th, 2019, consisting of 4 pages under mail log number 224935.
Marked as applicant exhibit 9.
Okay, thank you, Your Honor. Okay, so next is applicant exhibit 10. We would like to mark for identification the applicant's first settlement status update, which is filed on January 6, 2020. That consists of 2 pages under mail log number 228069.
Okay, I'll mark it as 10, but I'm going to have a question about that exhibit and the next exhibit's relevance.
Sure, Your Honor. So next up, we have it's 5 settlement status updates, all filed in 2021. We could maybe mark them all at once as applicant exhibit 11. And then if Your Honor would like to ask your question about the relevance.
Yeah, that's my question. What's the relevance of the settlement status updates that are filed in the docket?
Right. So I guess a few points. So, in most cases, applicants move settlement status updates into the record. So, I guess at a basic level, I'm just trying to be consistent with most solar CPCN cases.
That's not going to do it. That's not going to do it for me. What else do you have?
Another reason, Your Honor, is it provides some additional context to the settlement agreement filed by the applicant and PPRP in this case, kind of the lead up to that. So we were hoping to be able to provide that context and be able to cite to the updates in the record.
Do you think the settlement agreement requires context?
I think it does, Your Honor, because one of the statutory factors for the CPCN statute is the applicant's efforts to address issues raised by the county. So I think it does speak to that. Yeah, I'll leave it at that. I mean, I think it is relevant, Your Honor.
Okay. Does any other party wish to be heard on my question?
Your Honor, this is Sandra McLemore on behalf of PPRP. I believe this is relevant also in that it responds to some of the assertions made by KCPA witness Ms. Lewis Christensen, in that she had no knowledge regarding the settlement discussions that were being made at that time.
Okay.
This is Chris Drummond on behalf of KCPA. First of all, I don't know where Ms. McLemore comes to that conclusion. Secondly, I understand that this is an administrative or quasi-judicial proceeding, and rules of evidence are somewhat relaxed. However, it is fundamental in any matter that's contested, whether it's in court or I believe here in this context, that the settlement discussions to try to resolve the matter are always inadmissible. And to the extent that Mr. Bugelman's status reports discuss efforts between the county and the applicant, which were ultimately unsuccessful, and he does not explain why they were unsuccessful in any of those status updates, it would be impossible to divine from those status updates whether or not the applicant made a good faith effort to resolve disputes. So I think it's one, irrelevant, and two, Mr. Bugelman's undoubtedly will argue that the county was recalcitrant and refer to his many status updates as somehow evidence of the county's recalcitrance.
Okay, Mr. Drummond, we'll argue that at the time when it's discussed, if it comes up. They were filed, I believe, on behalf of all the parties that they were filed on behalf of at the time. So there's not an admissibility issue. I only had a question as to relevance, and they'll be. Well, Mr. Bugelman hasn't asked for them to be admitted, but when he does, he's taken care of my question regarding relevance. Please proceed, Mr. Bugelman.
All right, I was going to speak, but I guess I'll.
Oh, I'm sorry. Who's speaking now?
Mr. Yeager, I was just going to speak briefly on this, that to the concept that settlement negotiations should be confidential.
Sure, but these filings did not discuss settlement negotiations. They were updates as to the status of settlement.
Okay, understood.
Mr. Bugelman.
Thank you, Your Honor. So next up, we have applicant exhibit 12, which is the joint motion for approval of agreement of stipulation and settlement between the applicant and PPRP, which was filed on October 1st, 2021, consisting of 30 pages under mail log number 237256.
So marked as applicant exhibit 12.
Thank you, Your Honor.
Your Honor, before I object to the introduction of that so-called settlement agreement between the applicant and PPRP for the reasons set forth in the opposition that KCPA filed on October 7th, 2021, mail log 237345.
Okay, noted. Mr. Bugelman, did you move exhibit 11 into the record, which was now all the combined settlement status updates?
Your Honor, I haven't moved any exhibits into the record. I was going to mark all the exhibits and then move them all at once.
Okay. Mr. Drummond, do you understand we're marking for identification right now, and then we'll discuss objections?
I misunderstood. Thank you.
Okay. Mr. Bugemans, I'm sorry. Applicant 12, the joint motion with the settlement agreement is marked as applicant 12.
Thank you, Your Honor. And then finally, we have as applicant exhibit 13, the second public comment hearing compliance filing, which is filed on November 2nd, 2021, consisting of 6 pages under mail log number 237683.
Okay, and that'll be marked as applicant exhibit 13.
Thank you, Your Honor. And with that, I would move to enter applicant exhibits 3 through 13 into evidence.
Okay.
Your Honor, Kenneth Albert on behalf of staff, just a clarification. As I understand it, there's 1, 2, 3, 4, 5, 6 settlement updates. Those are all coming in or being marked for as exhibit 11. Is that correct?
I have 5 settlement status updates marked as collectively as applicant exhibit 11. Is that correct, Mr. Bugemans?
So the way I did it, Your Honor, was the original settlement status update from January 6, 2020 was marked as exhibit 10. And then the updates from 2021 were collectively marked as 11.
Yes, that's what I have.
Thank you.
Okay, so now I will entertain objections, starting with Kent County Preservation.
Thank you, Your Honor. I've already articulated the reasons for our objection to exhibit number 11, so I won't repeat them. As to number 12, which is what is called a joint settlement agreement or a motion to approve it, we set forth the reasons why we object to that document and believe it should not be admitted in our opposition to the joint motion dated October 7, 2021, and that was e-filed at mail log 237345, which I'm quite sure Your Honor has reviewed. Your Honor, I understand that there has developed over the years certain practices at the Public Service Commission, particularly between applicants and PPRP. And perhaps in uncontested cases, those practices promote efficiencies. However, in this case, we are proceeding in a highly contested matter, and it seems to me important that both the applicant and PPRP follow the law. And what the law says, at least as far as we argue, that it is the function of what are called the 7 secretaries to receive information from PPRP, which as best I can tell from reviewing the Public Utilities article and the Natural Resource article, is a clearinghouse for information from a variety of sources, which it then synthesizes and presents to the head executives of various interested state agencies. And it certainly makes recommendations to those secretaries about how or what should occur, whether a project should be recommended for approval, whether it should be recommended for approval with conditions, or whether there should be a recommendation contrary to the goals of an applicant. And that, in fact, occurred in this matter when the 7 secretaries submitted their letter in December of 2019. And PPRP undoubtedly assisted in educating the secretaries and may have, in fact, drafted their letter on their behalf. Now you have before us a proposal to quote, settle, which, as far as we know, the secretaries have either not reviewed nor endorsed. But the clearinghouse agency, which has no statutory authority other than what I have described, purports to act on the secretary's behalf, which it does not have authority to do. Consequently, we ask that that exhibit not be admitted. Thank you.
Okay. Mr. Drummond, KCPA is incorrect in the assertion that it makes in its motion that statutory authority is required for PPRP as a party to a CPCN proceeding to enter into a settlement. Statutory authority is not required to enter into a settlement. You are correct that settlements are often entered into not only between applicants and PPRP, but at times all parties to a CPCN proceeding. It's not just for efficiency, but if the parties have managed to resolve their issues and reach a settlement on those issues, it's perfectly acceptable to bring that settlement forward to the commission. Moreover, the secretarial letter specifically provides that the preliminary recommendation and license conditions accompanying that letter might be modified, and if so, a final recommendation and updated license conditions would be provided. There's no limitation on the presentation of evidence as to the factors which the Commission must consider under Public Utilities Article 7-207E. PPRP, as a party to this proceeding, may present evidence on any of those factors, including but not limited to efforts to resolve any issues presented by a county or municipal corporation where any portion of the generating station is proposed to be located. Efforts to resolve issues presented by a county or municipal corporation are of course not limited to efforts made only with that county or municipal corporation. So your objection is overruled and the settlement would be entered into the record. Although I've stated that, I will hear from the county and the town if they wish to be heard. Seeing nothing.
I apologize. I was waiting to see if the county stepped up. I would object to the status updates being admitted. I think that they are.
Again, you're a little faint. Mr. Court Reporter, are you catching this?
I'm with you. It's a little faint. Please speak if you can.
I'm going to change my device in a second, but I just wanted to make the objection before I do. I do agree that the status updates are irrelevant in regards to your ruling to submit on the settlement agreement between PRP and Morgnec Solar. But as far as the status updates, I don't believe that those have any relevancy towards the.
Okay, my thought on those is while, as Mr. Bugeman said, they provide, maybe not his word, but background for the settlement. They might not be completely necessary. I don't see any harm in them. So they'll be admitted.
If I may be heard as well.
Yes, and I'm sorry, it is slightly confusing because you have William and Mackey. So Mr. Yeager, correct?
Yes, thank you.
Okay, thank you.
Settlement negotiations and discussions are inadmissible. Simple as that. And the reason why they're inadmissible, because if settlement negotiations break down, then one side could be prejudiced by that. And we like to encourage settlements. We like to encourage parties entering into settlements. And that's why we have that rule to make them inadmissible. So if the fact is any substance of any proposed settlement with the county is inadmissible, and the fact that the county didn't go through with the settlement, and whatever reason the county chose to not go through that settlement and enter into the settlement is inadmissible and irrelevant, then the status of any settlements is inadmissible and irrelevant. So I would just argue that really it's not relevant, and it just is confusing to let them in. They serve no purpose. They actually defeat the purpose of why we have settlement discussions and cases. And the county's position is that anything regarding the settlement discussions should be inadmissible. They're not relevant to these proceedings. Thank you.
Okay, thank you. I do understand your position, but for example, I just pulled up the second status update dated July 30, 2021. It does not go into the substance, again, as I said to you before, it doesn't go into the substance of discussions. And in fact, it's filed on behalf of Counsel for Kent County, PPRP, and the applicant. And at the time this was filed, I can't imagine any of you are arguing you didn't receive this when it was filed. It didn't know about it being filed. No one objected at the time that this was filed that it contained inadmissible settlement discussions. And I really don't think it does. It's a status update as to the status of the settlement. I don't see anything substantive in these status updates.
But that's still not relevant. And the reason why we filed those was because of the timeline. That while we were attempting to settle the case, we didn't want to move forward with evidentiary hearings if they may not be necessary. That's why we did that. But, you know, for whatever reason, the settlement was not reached. So therefore, the statuses to the settlement is irrelevant, shouldn't be admitted.
Okay, well, as I said, I'm going to err on the side of allowing it in. I don't know that it is of extreme importance, but I don't see the harm. I'm not confused by them. And that was the only type of harm you mentioned. So they'll be admitted for the limited purpose they serve. So to clarify, I'm sorry, was there someone else?
That was me, Your Honor. This is a reporter. I need to get
Yes.
Mr. Yeager's full name and spell his last name. It doesn't show up anywhere on the computer.
Okay, my first name is Thomas, Thomas, middle initial N as in Nelson, last name Yeager, Yeager, and I'm the county attorney for Kent County, Maryland.
I appreciate that. Thank you very, very much.
You're welcome, and I understand the situation. I'm here on Mr. Mackey's computer, so I get it.
Okay, hearing nothing else, applicants' exhibits 3 through 13 are admitted into the record.
Honor, if I could interrupt it, and this is something that probably I should have raised a bit earlier. There are a number of folks, many witnesses I see on the screen, some of whom will not undoubtedly not be called today. I know at least one witness has another job. Can we, I don't know the protocol. Do we require people to remain on even though it's not likely that they're going to be called today? Or can we excuse them so they can go on with their lives today? So long as we, you know, nail down a little closer to in time when they're likely to be called.
Mr. Bugemans, I assume you were going to proceed to call your first witness?
That's correct, Your Honor.
Okay, do you have a time estimate for your witnesses in total?
I do not have a precise time estimate. I was roughly estimating perhaps 2 days. It really depends on the number of questions from the parties and, you know, how long it takes to get through them. But in my mind, I was thinking maybe 2 days would, you know, probably be enough time to get through all of them.
Okay. Mr. Drummond, if you have witnesses that would like to be excused for the time being, and I think they can certainly be excused for today, we'll have a better idea at the end of today how things will proceed tomorrow and Wednesday. Does that help?
Yes, thank you very much.
Your Honor, this is Mr. Yeager. I believe our witness, Amy Morgnec, who is former planning director of Kent County, who's currently the planning director of Queen Anne's County. She would be a witness for our case, so I would request that she be excused today as well.
Yes, that's fine. And just as I told Mr. Drummond, we'll chat at the end of the day today, just after we see how things are going, because it might be Wednesday. It's hard to say. Anyone else? Chestertown? Mr. Hicks might be trying to rejoin, so we'll check in with him.
I would request the same. I notified the mayor, my only witness, that I would notify better understanding.
Okay, so he's not on this morning.
Correct.
Okay. All right, Mr. Bugemans, if you could please proceed.
Thank you, Your Honor. The applicant would like to call his first witness, Dr. Edward Otter.
Okay, and do you have a attestation for me?
I do. I hereby attest that the witness is alone in a separate room and not in communication with any other individual.
Thank you for that.
Thank you, Your Honor.
I didn't get the witness's name. Somebody clicked in at the time.
Okay, yeah, we'll go over that. I'm looking for him. Dr. Otter,
Yes.
is your screen on? There you are. Thank you. Can you please state and spell your name for the court reporter?
Edward Otter, Otter.
Okay, and can you raise your right hand, please? Do you swear or affirm under the penalties of perjury the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Mr. Bugelmans, your witness.
Thank you, Your Honor. Good morning, Mr. Otter. Can you please state your name and provide your business address?
My name is Edward Otter. My business address is 1704 Camden Avenue, Salisbury, Maryland.
And what is your company and title?
Edward Otter, Inc.
Thank you. Do you have before you a document entitled Direct Testimony of Dr. Edward Otter, dated August 2nd, 2019, consisting of 82 pages inclusive of attachments?
Yes.
Thank you. Your Honor, I'd like to request this document be marked for identification as applicant exhibit 14.
So marked.
Thank you, Your Honor. Dr. Otter, do you also have before you a document entitled Supplemental Rebuttal Testimony of Dr. Edward Otter, dated October 29th, 2021, consisting of 5 pages?
Yes, I do.
Thank you. Your Honor, I'd like to request this document be marked as applicant exhibit 15.
So marked.
Thank you, Your Honor. Dr. Otter, were these documents prepared by you or under your supervision and control?
Yes.
If I were to ask you the same questions today, would your answers be the same?
Yes.
And is your testimony true and correct?
Yes.
And is your testimony true and correct to the best of your ability?
Yes.
Thank you, Dr. Otter. With that, I would request to move applicant exhibits 14 and 15 into evidence.
Any objections? Hearing no objections, applicant exhibits 14 and 15 are admitted into the record.
Thank you, Your Honor. And with that, the witness is now available for cross-examination.
Okay, as I said, Kent, Conservation and Preservation, do you have any cross-examination for this witness?
I apologize for the delay. I thought PPRP was second, but I'll.
Let me explain. We don't do friendly cross, and PPRP has filed a recommendation to approve the project. Therefore, they would have, they wouldn't cross-examine this witness. So you'd be next up.
Thank you. Dr. Otter, my name is Chris Drummond. I represent Kent Conservation and Preservation Alliance. Can you hear me satisfactorily? Thank you. Dr. Otter, it is my understanding that you, in your archaeological work on this property, availed yourself of the Maryland Historical Trust guidelines. Is that correct?
Correct.
And those were published, as I recall, in 1994.
Correct.
And I'm sorry, I've got. Apologize. And they've not been updated since 1994.
Correct.
And the Maryland Historical Trust guidelines are principally interested in locating, examining, documenting structures.
No, that's not true. They cover both structures and archaeological resources.
Archaeological resources are those resources that may be found below the surface?
On the surface and below.
and to examine or uncover, as it were, quote unquote, resources that are underground. You chose to dig some holes. Is that right?
For the underground stuff, yes, we did excavate holes. We also conducted surface survey looking for evidence in that form.
And you did not use other available methodologies for in an attempt to discover resources that might not be visible.
No, we did not. Surface survey in that portion of the state is sufficient to find most archaeological sites.
Most archaeological sites or items of interest to Maryland Historical Trust. Is that right?
All sites, period.
What other methodologies are available to you other than digging holes?
Well, surface survey, as we did here. If you're prospecting for sites, then you're rather limited. The electromagnetic resources such as ground penetrating radar, magnetometry, resistivity testing, those are really designed to work on specific sites that have pretty much already been identified.
That, in point of fact, haven't two sites been identified on the Clark farm?
Two house locations were known, but they were not precisely mapped as archaeological sites until my work.
The survey work done on behalf of the Maryland Historical Trust in the late 70s and in 1980?
They did not survey those portions.
I asked you if you, wait a minute, I asked you if you reviewed them.
Oh, yes, when I wrote the report.
Therefore, you became aware that two home sites, homesteads, had been surveyed and documented.
Yes.
All right. And in your experience, Dr. Otter, is it likely that there are archaeological resources beyond the foundations of such historic residential structures?
Could you rephrase the question?
Can't rephrase it, I'll repeat it. Is it in your experience likely or to be expected that there would be archaeological resources beyond essentially the foundations of historic residential structures?
Yes, it's possible.
By possible, is it unusual, for example, for 17th or 18th century residential farmhouse to have surrounding it outbuildings?
Yeah, it's normal to have outbuildings.
And when those historic residential structures are located on properties with a known history of slave labor, would it be unlikely or unusual to find evidence, archaeological resources relevant to that labor?
Repeat that question.
Said when the 17th or 18th historical structures are located on properties known to use slave labor, would it be unusual or unlikely to also find archaeological resources regarding that labor?
It could be possible.
Where, when you did your research, Dr. Otter, that in point of fact, the Clark farm was known to have used slave labor in the 17th and 18th centuries?
Most large farms had used slave labor. It's not unusual.
And notwithstanding what you've now told us, including your review of the 1970s to 1980 surveys of the property, your knowledge of the likelihood of the use of slave labor. You did not use any of the other methodologies that you've just described, such as ground penetrating radar, to search for archaeological resources beyond essentially the foundations of those residential structures. Other than conducting what you've described as a site survey, which I take it to mean you look around at what's obvious from your eyes.
The excavations on the sites were intended to determine whether there were sufficient and significant archaeological resources that could be used to make interpretations about the past. Our determination in the field was that that is not the case on these sites. They've been disturbed to the point where most of the cultural resources, the features as we call them, are disturbed or completely removed.
That a basement or cellar was identified in the MHT surveys from the late 70s and 1980 at the Hopewell House. Is that right?
I don't recall.
You don't recall. You told us that you reviewed the MHT surveys from the late 70s and 1980s.
I said I reviewed them before I wrote the report.
Not recall that a basement was identified. It's a cellar, basement, whatever you want to call it. Is that right?
I said I don't recall whether they stated that or not.
But if that report or survey reports the presence of a cellar, was that of interest to you in your examination of the Hopewell site?
We found no evidence of a cellar when we dug our excavations, and the excavation plan was pre-approved by the Maryland Historical Trust.
That's the point, isn't it? That you did only what the Maryland Historical Trust told you to do.
That's pretty much what I have to do. They're the review authority. They have the statutory authority to approve my work, so I have to do what they tell me to do.
No more than that.
Pretty much. I balance a line between my client's interests and the requirements to get the project approved.
Since your report, Dr. Otter, you have received information regarding the self-emancipation of Harriet Shepard. Is that right?
I have.
And you reviewed Ms. Fritz's testimony.
I have.
That would be the sort, correct me if I'm wrong, cultural resource information that would not lend itself to discovery by digging holes.
I don't know that the fact that a emancipated slave worked on that farm is actually a cultural resource.
You're dismissive of the significance of that information?
No, I'm not dismissive. I just, in terms of it being a resource, something you can hold on to or point to. I mean, it's certainly a historical, it could be a fact. I have not seen any reference in Ms. Fritz's work or anywhere else that specifically and thoroughly identifies the self-emancipated slaves as being the property of that property's owner.
And do I understand it that in your role to promote the application of Morgnec Road Solar, you are uninterested in finding out more about that story and whether it's directly related to the Clark farm?
No, I do not believe that's a fair assessment.
Tell me what the fair assessment is then.
It's not my position.
In other words, it's not part of your portfolio to determine whether or not the Clark farm is of significance to the self-emancipation of Harriet Shepard.
I'm sorry, Your Honor, I have to object to this. I mean, this is a mischaracterization of Mr. Otter's, or Dr. Otter's supplemental rebuttal testimony. He covers the self-emancipation history in his rebuttal testimony. This is completely mischaracterizing his testimony.
I think that he can clean that up if he wishes to. And
Well, Mr. Drummond, I have to say, I haven't understood your last two questions. So if you could back up and maybe ask your question so it's clear, and then give a chance for Dr. Otter to respond.
Lawrence, I understand that, but Dr. Otter apparently understood my second to the last question because he answered it.
Okay, well, let's, I have an interest in making sure the record's clear. And as I said, I didn't understand your last two questions. So help me understand what you're trying to get from Dr. Otter right now.
Otter, you understand that one of the factors that Judge Lawrence must consider in the CPCN application is the effect, if any, that this solar project will have on cultural, including archaeological resources. You understand that?
I understand that.
And I'm asking you whether you have been called upon or have undertaken an examination or study or investigation of the Clark's Farms connection, if any, to Harriet Shepard in light of the information recently revealed.
And if my recollection of his answer was that he hadn't seen anything that connected those two things. But go ahead, Dr. Otter, if I got that wrong.
What I have not seen is any document that thoroughly ties Harriet Shepard to the ownership of Mr. Peterkins, I believe. Therefore, it's not positive that she was owned by him or worked that farm. On a second point,
Let him finish.
The archaeological remains out there would not be sufficient to make any meaningful interpretations about anyone's life or use of that property.
And you find, and you have no interest in, I'm not saying that personally you don't have any interest, but you don't have any interest in given your role in this case, to further investigate.
My role was terminated when the Maryland Historical Trust approved my archaeological report.
All right, that's all I have. Thank you.
Kent County.
That's all
I understand. Kent County, do you have any questions for this witness?
Dr. Otter, did you consider or read the testimony of Marcia Fritz at all?
I have the supplemental testimony of Marcia Fritz.
And the fact that it is documented that there was a self-emancipated slave on the property, that was not something that you considered?
It is stated in there, but there is nothing that provides true evidence of that ownership or use of that farm.
Well, but you would agree with me that there is significant evidence that the self-emancipated slave had a connection to that farm.
I don't think I can agree with you on that. There's nothing that proves that.
And I take it that you did not look into that and do any investigation and try to learn more to determine if there's any additional proof with respect to the self-emancipated slave. Essentially, you got the information and you just dismissed it.
No, that's not true. I looked up the application for the Underground Railroad that was denied. And the references that are mentioned in there, William Still's ledger, and there's another ledger, a couple of websites, and none of those provided a factual document that states true ownership. One website, it's one of the references, I think it's Eastern Shore something or other. It's on the website. They say sort of maybe owned it, but even that was not a definitive statement.
Well, I'm going to direct your attention to testimony of Marcia Fritz, where it says the question was, what is the historical or cultural significance of the Harriet Shepard self-emancipation story? And Ms. Fritz says, my research and that of others establishes that Ms. Shepard was the slave of George W.T. Perkins, owner of Hopewell, and the other Kent County properties in the mid-19th century. Ms. Shepard and her family escaped from bondage to Mr. Perkins in 1855. She has gained some prominence as a result of her escape from slavery. A more careful analysis of the Clark farm, using the techniques I've described, may uncover much more information about the lives of slaves on the property in the 17th and 18th centuries. Tying that information together with Harriet Shepard's remarkable story would provide an important and culturally significant narrative that so far has been overlooked. So I guess what I'm saying to you, sir, is that you chose not to attempt to uncover any more information about the lives of slaves on that property. Is that fair to say?
In what time frame? Since I saw Ms. Fritz's testimony, I did attempt to check the references, academic standards, and of course I recognize that this testimony is not an academic standard, but academic standards would have provided the references, whether it's census records or deeds or other documents that would have firmly established the ownership of Harriet Shepard and her children. And that was not provided in any of the references that I looked at. On the second point, the archaeological remains on the two sites are insufficient to provide meaningful analysis for archaeological purposes. There's not enough out there in situ to make meaningful statements about what people were doing there.
Okay. You never inquired of Ms. Fritz what her research was, did you?
No, and
you didn't inquire of her what research of others that she reviewed, did you?
No.
That's all I have.
Mr. Hicks, are
Thank
you
you,
back
Art.
with us?
How's it sound? A little better?
Yes, thank you.
All right. Dr. Otter, Jesse Hicks, how are you doing?
I'm good.
Just want to get into a little bit through the Maryland Historical Trust. So you're hired by Urban Grid, correct?
Yes.
And then you're kind of instructed by MHT to do this review.
The Maryland Historic Trust used their statutory authority to ask Urban Grid to have a archaeological survey conducted. They hired me to do that.
Urban Grid hired you?
Yes.
Okay. And Maryland Historical Trust, they told you to do this phase 1 survey, correct?
They stated they wanted a phase 1 survey. I developed the research design and performed it, and then they reviewed that.
Do they approve your research design first, or do you do the research design, do the review, and then submit your report to them?
Usually on phase 1s, the survey is done first and then reviewed.
Okay. How many different phases are there? This is just kind of my naivety.
There are 3. Phase
Three.
1 identifies sites. Phase 2 determines the significance of those resources. And phase 3 mitigates effects that a development would have on those resources if they're sufficient and significant.
So you didn't even move to a phase 2 review?
Almost. They asked for some supplemental work on the phase 1, which they did pre-approve the scope of. And I'm not sure why they didn't ask for phase 2 instead, but they didn't.
Have you included that supplemental report in your exhibit that you provided through your direct testimony?
Yes, it's in there. It's a unified report.
Okay. So it doesn't say in there it's supplemental, you just provided it as one exhibit.
Yes.
Okay. And you never got an answer from them why they didn't proceed to phase 2?
They didn't proceed. No, I never asked the question as to why they asked for supplemental phase 1 rather than going to full phase 2.
Okay. Through your direct testimony, it says that then MHT, upon your report filed with them, they do an independent review, correct?
They review my report.
Right, but you put in your direct testimony, it's an independent review, so you have
Yeah.
some understanding of what they do.
Yeah,
Okay, but you don't really know what that independent review is.
correct.
Okay. Does MHT send a representative out with you when you do your survey or do your digging?
No.
No. Do they have any other reports submitted to them, say by the National Historic Registry or Kent County Historical Society, anybody like that?
No,
Okay.
I don't believe so.
So it's just they take your report, they review it, and make a decision.
As far as I understand, yes.
Okay. Do they issue a written response or do they just tell you verbally?
Written response.
Okay. And where's that written response?
I believe wasn't that included in the testimony?
I have that you said that they believe that you say in your direct testimony that MHT said to you that it does not meet the standards or that they agreed with your findings.
Can you repeat that?
Court's indulgence, Your Honor. Let me just bring up his. In your direct testimony, page 6, line 17, question, with respect to archaeological resources, what was MHT's response to your phase 1 investigation? Your answer, after reviewing my findings, MHT concluded that the identified sites do not meet the criteria in the National Register given their loss of integrity and inability to yield any additional information. MHT concluded that further investigation of these sites is not warranted. You see that?
Yes.
Okay.
Yes, that's correct.
Was that provided to you in writing, though?
Correct.
Okay, but you didn't provide that as an exhibit.
It's included in letters to Power Plant Research Program. It wasn't, and I was CC'd on it.
Okay, have those been submitted as exhibits? To the best of your knowledge. Sorry.
Were they included in the package?
Your Honor, I would object to him asking the attorney questions during
I don't remember what was.
Yes, Dr. Otter, just if you don't know in your own personal knowledge, that's okay. Just say you don't know.
And I have no problem with that answer. It was kind of an inappropriate question to ask you. It goes to the attorneys. That's my fault. It's a bad question. But so there was some written report submitted to you.
I was.
He stated that he was CC'd on a letter to PPRP.
Just kind of reestablishing the question, Your Honor. I apologize. So when I look through your report, you include a lot of historical context, correct?
Yes.
Okay, and that's so that you have an idea of where to look, so you're not just kind of looking for a needle in a haystack, correct?
It's twofold. It's partly so we know where to look, but in this case, we looked everywhere for any site we could find. The other reason we do historic context is when we do find a property, then we have some form of a historic context in which to evaluate that find.
Okay. And nowhere in your report does it mention this Harriet Shepard, and we can get into why, but it's not mentioned in your report, correct?
Correct.
Okay. You said earlier what the name of the individual who possibly owned slaves in that property. What was his name?
I believe it was Peterkins.
Peterkins. Okay, so you don't even know the name of the landowner.
It was in the title chain. That work, which pretty much I copied, is the Maryland Historic Trust file that was actually prepared by Marcia Fritz back in 1980.
Okay, but you just stated, I forget whose cross-examined it was, that upon receiving Martha Fritz's direct testimony, you did some research into Harriet Shepard and her self-emancipation, correct?
Minimal.
Minimal.
I checked some of the references that were
Minimal in
provided.
that you can't even say what the name of the possible slave owner was.
I believe it was Peterkins, but this has been fast and furious for me, and so yeah, it is what it is.
Based on that testimony from Martha Fritz, did you do any supplemental reports to MHT notifying them that there is this possible reference to an emancipated slave, self-emancipated slave?
No.
No. Did you do, as far as the historical research, you said it was minimal. Did you do any research into, let's say, the potential story behind Miss Shepard?
I looked at the references that were provided in the Underground Railroad application.
Okay.
That was denied.
Okay.
And that's most of what I've done. I don't have access to all of the resources that I might like to look at because of distance, and so it would be. And quite frankly, I'm a consultant, and I'm not going to go researching this project, just because I want to.
Right. You don't want to unearth some archaeological site that would then ruin the project for your
There
client.
are archaeological sites out there.
Okay. But when you say this references, it kind of was unresponsive. I asked you, are you aware of even the story of Harriet Shepard?
I'm aware of it due to Ms. Fritz's supplemental testimony.
Okay, but not from your own research.
Correct.
Okay. Did you even go through any of the online Maryland archives regarding Ms. Shepard?
No.
Okay. Would it surprise you that a cursory search of the Maryland archives does show the context behind Harriet Shepard, Kent County, and the potential being connected to Kent County?
Repeat that?
Would it surprise you to know that a cursory search of the Maryland archives would show that Miss Harriet Shepard was potentially owned by George Perkins in Kent County and was self-emancipated at that time?
I'm sorry, Your Honor. I have to object to this. If counsel wants to ask questions about actual documents in the archives, he can do that. But he's just we've been unable to verify any of this. It's completely speculative.
We've been unable to verify it because Dr. Otter hasn't done any type of research into the project. And a simple cursory search.
Mr. Hicks, your question was
That is
not proper.
correct.
Hold up, everyone. Mr. Hicks, your question was not a proper question. Do you
Thank
have
you, Your
another question for this witness?
I do, Your Honor. So in your findings, one of the things you mentioned is that you recommended that this site does not meet the criteria for National Registry, correct?
Correct.
But you kind of imply that because of the destruction of the property that it wouldn't be, it wouldn't meet that criteria.
That's not a question. Ask a question.
I said he implies that the destruction of the property is the reason why it wouldn't meet the criteria, correct?
That is correct.
Okay.
My focus was archaeological resources. The Maryland Historical Trust had already determined the buildings that were there to be not eligible under the other criterion of the National Register, which includes significance with individuals important in history and events and architecture. So mine was the fourth piece of National Register significance that was archaeology only.
Okay. I don't know anything further, Your Honor.
Any redirect, counsel?
A few questions, Your Honor. Dr. Otter, you've spoken a bit about the back and forth with the review process with MHT, correct?
Yes.
And isn't it true that as part of that, MHT reviews your plan, and if there's a deficiency with your report, they'll go back to you and have you correct either your work on the field or the contents of your report. Is that right?
Yes, that's correct.
Are you able to elaborate a bit as to why MHT did not require a phase 2 on the site?
No, I'm not. I don't understand why they didn't.
Isn't it true, Dr. Otter, that, well, I guess backing up a second. So in terms of documented historic buildings on the site, there are two buildings, correct? Black Hall's Hermitage and Hopewell. Is that right?
Yes.
And isn't it correct that as a result of your MHT approved survey plan, you determined that
Objection real fast, and Judge, just tell me if I'm out of line. I realize that things are a little relaxed here. This isn't a court, but what I'm concerned about is that counsel is asking questions that tend to suggest the answer, which are very leading. And I think for purposes of this hearing, while in cross-examination, leading questions are acceptable, but in a direct examination, I would just ask that the questions be more open-ended and not leading as they are, not have questions that suggest the answer in a direct.
I understand, Mr. Yeager. You are asking leading questions, Mr. Bugelmans. Can you try to phrase them such that they're not, please?
Okay, Mr. Otter, what was the result of your archaeological survey on the site with respect to those two buildings?
The initial survey identified the location of the buildings and made a determination that they had been heavily impacted by plowing and erosion.
And what did you discover in terms of any remains on the site with respect to those two buildings?
That they had been heavily disturbed by demolition and agriculture. The only thing we found relatively intact was the very bottom portion of a stone foundation, and it was displaced rocks, so even what was left was not fully intact. So everything above and around was gone.
Is that type of condition common on a farm site such as this?
Yeah, once they go into agriculture, they don't want those stone foundations out in the field to mess up their plows and things like that.
Does that conclusion, oh, I'm sorry.
Demolition tends to be thorough.
Does that conclusion carry over to any potential remains related to slaves on the site?
Well, if they're going through the process of removing the buildings down to and including foundations, all of the materials that would have been present from any slave activities would be removed, displaced, and scattered. So there would be no intact archaeological deposits to study.
So isn't it true that,
Isn't true.
I'm sorry?
Was there an objection?
Yeah, that's what I was waiting for. Thought I heard something.
You weren't going to ask another leading question, were you, Mr. Bugelmans?
I was not, Your Honor. Well, I'll try not to.
Thank you.
Let me give it a second here. Would you expect? Okay. Would you expect assuming that there is a connection between the site and Harriet Shepard, would you expect to find any remains based off of your experience with the site related to her on this property?
If a connection could be established, the pottery could be dated and might be of the right time period. But that's about all we could do with material spread through a plow zone.
Why wasn't Miss Shepard included in your report?
She never showed up in the research that I did. Well, when I put together my historic context, there was no indication of her. Many of the resources that are available today weren't available back in 1980 when Ms. Fritz put together her assessment of the buildings, or even some of the materials that I looked at when I did my analysis. She just didn't show up anywhere.
Dr. Otter, is the MHT review process limiting in terms of the work that you do on this site in particular and also generally?
It can be.
In what way?
In what way?
Well, they have the guidelines are old, and they need to update them, but they haven't, and they sometimes don't interpret their own guidelines the way that they're written.
Would that have changed any of the results on this property?
No, it wouldn't. The methods that I used with the surface survey is actually superior to doing shovel tests all over the property.
Okay, that concludes my questions, Your Honor.
Thank you. I don't have any questions for you. Thank you for your testimony today.
Am I done?
You may be excused, yes.
Thank you.
Thank you, Your Honor. The applicant would like to call its second witness.
Yes.
We
Mr.
would like to
Clark?
call Mr. Robert Clark.
Mr. Clark, is your camera on?
There we go. Oh,
There, I see you now.
hello.
Good morning. Can you please raise your right hand, sir?
Good morning. My name is Robert Clark. Whoops. My screen is freezing.
Yeah, there was a spinning circle on your square. Do you have sufficient bandwidth where you are, Mr. Clark?
Yeah, I have good battery. Unfortunately, where I live on the Eastern Shore, we don't always have good Wi-Fi or cell phone.
Okay, well, at the moment, I see you and I hear you. If we get to a point where we can't hear you as well, I will ask you to turn off your camera because that might help. But at the present time, I'd like you to keep it on while you raise your right hand.
Okay,
Do you swear or affirm until penalties of perjury the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Can you spell your name for the court reporter, please?
Okay, Robert, R-O-B-E-R-T, Clark, C-L-A-R-K.
Thank you. Mr. Bugemans, please proceed.
Morning, Mr. Clark. Can you please state your name and provide your business address?
Okay, it's Robert Clark. My address is 25459 Howell Point Road, Betterton, Maryland.
Thank you. Do you have before you a document entitled Direct Testimony of Robert Clark dated August 2nd, 2019, consisting of 4 pages?
Yes, I do. Yes, I do. I repeated that.
I'm sorry, Mr. Clark. Yeah, I don't know if that was a problem for everybody, but I was unable to hear your answer. Could you please repeat that?
Okay, yes, I do.
Thank you,
Did
Mr.
you hear
Clark.
him?
I did.
Did you hear him that time? Okay.
Yeah.
I did, Your Honor. Your Honor, I would like to request this document be marked as applicant exhibit 16.
So marked.
Thank you, Your Honor. Mr. Clark, was this document prepared by you or under your supervision and control?
Yes.
If I were to ask you the same questions today, would your answers be the same?
Yes, it would be.
Is your testimony true and correct to the best of your ability?
Yes, it is.
Thank you, Mr. Clark. With that, Your Honor, I'd request to move applicant Exhibit 16 into evidence.
Any objections? Hearing none, applicant 16 will be admitted into the record.
Thank you. And with that, the witness is now available for cross-examination.
Kent Conservation and Preservation, Mr. Drummond. Do you have any questions for this witness?
Yes, Your Honor, thank you. Mr. Clark, my name's Chris Drummond. I represent Kent Conservation and Preservation Alliance. Are you able to hear me satisfactorily?
Yes, sir.
Good morning. Mr. Clark, would you be the Robert W. Clark that purchased the tracks on which the solar facility is proposed on well, certainly before January 20th of 1996?
No, I would not be. That you would be thinking of my father, who passed away a few years ago.
How long did your father and presumably your mother own this property?
That is correct.
No. When did they purchase it, if you know?
It was passed on to my parents from my grandfather.
Right. So the Clark family has owned this tract of land for many decades. Is that correct?
Yes, approximately 60 some years.
And it has been continually in agricultural production for those 60 years. Is that correct?
Yes.
So, and who is Chip Yowell? Mr. Clark?
Excuse me?
Who is Chip Yowell? Yowell.
Okay. Chip Yowell is my brother-in-law. He married my sister.
So when Mr. Yowell testified, or in his written testimony, referred to this property as an investment property, that's not correct, is it?
No, it is correct.
But your grandparents purchased it 60 years ago as an investment property?
Yes.
See, and they were investing in agriculture.
I would rather say they invested in land.
They had used it, and your father has used it, and you have used it every year for agricultural production.
Yes, we have.
Okay. And Mr. Clark, do you or members of your family actually till the property, or is it leased?
It is currently leased. I am the one that is leasing the farm. Farming is my occupation, and currently it's the Fair Promise Farm LLC that is leasing the property from me and my sister.
Broke up a little bit, but let me make sure I heard what you said. The family partnership is leasing the farm to you and your sister.
No, the family partnership is leasing it to Fair Promise Farm LLC, which is me and my son.
Okay, all right, fair enough. And how long have you and your son, the LLC that is of which you and your son are the members, how long has that LLC leased the farm?
I believe we formed the LLC approximately 6 years ago.
And prior to the formation of the LLC, was the property leased?
Yes, it was. It was leased to me as my farming operation.
How long have you actually tilled the farm?
I am 71 years old now. I started the day I got out of college.
About 50 years then, thereabouts.
Yes, every bit.
Over the last, let's say, 10 years, could you describe the crop rotation on the farm?
The last 10 years, it has been a full season soybean followed by a no-till cover crop of wheat, generic wheat.
Grain crops then are soybeans and winter wheat.
Yes. Well, winter wheat as a cover crop.
Okay. So the only grain crop then has been soybeans.
I get some.
Mr. Clark, what soil management techniques or programs have you used on the farm over the last decade?
Could you rephrase that, please?
Have you used any soil management programs or techniques on the farm over the past decade?
Well, I can tell you how each cropping year begins. It starts in the fall with soybeans when they get harvested, and what we do is we watch the moisture content, and hopefully it gets down close to 13.5%, and then we
The moisture, well, 1 second.
harvest and excuse me.
That would be the moisture content of the beans, right?
Yeah, that is correct.
Right. Mr. Clark, what I'm asking, I suppose, more specifically is what, if any, amendments to the soil have you made to increase the organic material elements of the soil?
Well, we take soil samples every year, and at that point, we determine what fertilizer, chemicals, etc., may be needed to grow a crop the following year.
And has that included organic material supplements to the soil?
The organic supplements that are used are the crop residue and the burn down from the cover crop wheat in the spring, and it's all done according to our nutrient management plan.
Well, the nutrient management program addresses phosphorus, nitrogen, those sorts of elements in the soil. Am I correct?
Yes.
They do not address organic matter in the soil.
No, it does not.
Are you familiar with the soil amendment recommendations for organic matter issued by the University of Maryland Extension Service?
I am aware that they do have a program to bring in chicken litter, but we have not gone that route.
Are you familiar with the programs recommended by a variety of extension services across the country for improving organic matter percentages of soil?
Yes, I am.
And have you practiced any of those recommendations on this farm?
I believe I have, in that we have gone 100% no-till, so we do not disturb that organic matter. If anything, we try to incorporate it a little bit when we do our no-till operation.
And that would consist of disking in the winter wheat?
We no-till our soybean crop, and then we come back with no-tilling in our cover crop of winter wheat.
Clark, you agree with me that even prime agricultural soil needs regular management for balancing pH?
Again, I say,
And wait a minute, and improving the presence of organic matter?
when a soil sample is taken, it does check to see what the organic matter is on the surface of the soil. And we follow all the recommendations that were given. So
That wasn't my question, Mr. Clark. My
Okay.
question was whether you agree that even prime agricultural soil requires management to maintain and balance pH and to maintain and if necessary, improve the presence of organic matter.
that's a good question. I don't know quite how to answer that.
That's okay. If you don't, that's fine. Just say so.
Excuse me?
I said, that's fine. If you don't know the answer, that's fine. Just say so.
Sorry.
Is crop rotation important to maintaining the productivity of soil?
Yes, it does.
Okay. Mr. Clark, did a John Hall contact you and request information about the actual crop yields from your farm?
No.
To your knowledge, did Mr. John Hall contact anyone in your family or otherwise associated with the farm to determine the actual yields from crops grown on the farm?
Not that I'm aware of, no.
John Hall contact you or anyone in your family or affiliated with the farm about the value of the crops grown and then harvested from your farm?
No.
Did John Hall contact you or any member of your family or anyone associated with the farm to inquire about the cost of producing crops on the farm?
Not that I am aware of, no.
Clark, as one intimately familiar with the property, you're aware, of course, that there is a ridge on the property that is in an east-west orientation, essentially parallel with Route 291. You're familiar with that?
Yes, I am.
And can you see that ridge from, if you're driving down 291 towards Chestertown?
I'm sorry, Your Honor, I have to object to this line of questioning. This is outside the scope of Mr. Clark's testimony. He testifies to his experience.
Sustained.
I don't have any other questions. Thank you.
Yeager. Do you have any questions for this witness, Mr. Yeager? Mr. Hicks, do you have any questions for this witness?
I have no questions. We were struggling with the mouse there, but I have no questions for the witness.
Thank you. Mr.
Based
Hicks?
upon counsel for KCPA, no, Town Chesterton doesn't have any questions for this witness.
Okay. Any redirect, Mr. Bugelmans?
I have no questions, Your Honor.
Thank you, Mr. Clark. You are excused. Have a good day. At this point, I would like to speak to Ms. McLemore if she's available. Check in on Dr. Hall.
Your Honor, we haven't heard anything today, but we will try in the next 5 minutes to reach out to him and
Okay, I think he
see
was on
what
the
exactly
call.
going on at this time. If that's okay, can I let you know in 5 minutes?
Yes, I did see him a minute ago.
Okay.
But now I don't. So I wanted to see if there was an update if you needed to have him go out of order. But that's fine. We'll go on to the next witness. Mr. Bugelmans.
Lawrence, I want to be clear. I'm not speaking too loudly, I hope. I've been told that sometimes people can't hear me in the Zoom context, and I'm kind of yelling. If it's too loud, let me know.
Is this Mr. Drummond?
Yes.
Volume is fine on my end. Mr. Court Reporter?
It was a little loud.
Okay. You don't have to yell, Mr. Drummond.
Okay,
we can hear you. The court reporter is very good. He will let you know if he can't hear you.
Okay.
Okay. Mr. Bugelmans, your next witness, please.
Thank you, Your Honor. Next, we will call Mr. John Yao.
Mr.
John,
Yao.
are you?
I see him.
Okay, I'm sorry. I had to unmute. I apologize.
No, that's fine. Can you please raise your right hand, Mr. Yao?
Yes.
Do you swear or affirm under the penalties of perjury the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, back to you, Mr. Bugelmans. I need an attestation, please. Did you give one in general, or were you doing it per witness?
I'm sorry, Your Honor. You were breaking up there. Could you repeat that, please?
Yeah, there was a little something. I don't recall now. When you did your attorney attestation, did you do it broadly, for all witnesses, or were you doing it per witness?
That's a good point. I did it as a singular, so I think it was just about that one witness.
Okay, would you mind taking a step back and doing it then for Mr. Clark, and then doing it for this current witness?
Yes, Your Honor. So with respect to Mr. Clark, I hereby attest that the witness is alone or was alone in a separate room and was not in communication with any other individual. And with respect to Mr. Yao, I also hereby attest that the witness is alone in a separate room and not in communication with any other individual.
Thank you for that, and I apologize for forgetting for Mr. Clark.
Sure.
Okay, Mr. Yao, if Mr. Bugelmans, Mr. Bugelmans, you're getting the spinning circle on my end, so I don't know what's happening in your office, but
I think the issue, Your Honor, is possibly with our firm's firewall. Our intent is at the lunch break to try to fix it, but we didn't want to disrupt the hearing.
Okay.
But we think we know how to fix it, and hopefully it'll be better after the break.
Okay, great. Go ahead. Sorry.
Thank you, Your Honor. Hello, Mr. Yao. Can you please spell your name and provide your business address?
Yes, it's John, John, Yowell, Yowell. And our home address, the home address is 25260 Howell Point Road, Betterton, Maryland, 21610.
Thank you. Do you have before you a document entitled Direct Testimony of John Chip Yowell, dated August 2nd, 2019, consisting of 3 pages?
I do.
Thank you, Your Honor. I would like to request this document be marked as applicant exhibit 17.
So marked.
Thank you, Your Honor. Mr. Yowell, was this document prepared by you or under your supervision and control?
Yes, it was.
If I were to ask you the same questions today, would your answers
They would be the same answers.
be the same? Is your testimony true
They
and
would be the
correct to the
same
best of
answer.
your... Thank you, I heard that. Is your testimony true and correct to the best of your ability?
Yes, it is.
Thank you, Mr. Yowell. With that, Your Honor, I'd request to move applicant exhibit 17 into evidence.
Any objections? Hearing none, applicant exhibit 17 is admitted into the record.
Thank you, Your Honor. The witness is now available for cross-examination.
Mr. Drummond, do you have any questions for this witness?
Your Honor. Mr. Yao, my name's Chris Drummond. I represent Kent Conservation and Preservation Alliance. Can you hear me?
I can hear you, yes.
Okay, thank you. Mr. Yao, in your testimony, you responded to a question: how long have you and or your family been farming on the eastern shore of Maryland? And in your answer, you referred to the Chestertown farms, plural, as purchased as an investment. Recall that?
Those are 2 different answers. Yes, I recall both of those pieces of information.
Okay.
The family has been farming in the Betterton area between 1954 and 1955. That's how long they've been farming on the Eastern Shore.
Right. And you referred to the Chestertown farms as investment properties.
Correct.
And they were, as you heard, if you were listening to your brother-in-law's testimony, purchased by his grandparents many decades ago.
Correct.
And they have been farmed continuously by the Clark family, that is the Chestertown farms, since they were acquired many decades ago.
Correct.
And in fact, Mr. Clark himself.
I'm getting an echo in here, and I think somebody's got the...
Mr. Yowell, do you have your computer turned up to hear the hearing? Is it possible to turn it down?
I can try. How's that? Is that better?
Mr. Drummond, can you ask a question?
Yeah, that's...
In fact, your brother-in-law, Mr. Clark.
Okay, I think that's better. Thank you.
Okay, sure.
Has tilled the farm himself and with his son for at least 3 or 4 decades. Correct?
I don't know the number of years, but a long time.
So when your grandparents-in-law purchased the property decades ago, they bought it for farming purposes.
According to conversations I had with Rob's father, they were purchased as an investment for future development. And they farmed them as they waited for that to happen.
And the quote unquote development of the farms in your conversations with your, I guess, father-in-law would be for residential development.
That was the conversations we had, yes, even though the property is zoned for commercial and industrial development.
It's your belief that the property is zoned for commercial and industrial development
Parts of it are, yes. Mhm.
today?
Right this instant, yes.
Do you know, what are the zoning districts of the property, Mr. Yao?
I can only tell you that commercial is one of them. I believe light industrial is one of them. Those are the two that come to mind. I don't have a zoning map in front of me, but parts of the farm are zoned that way.
And how long do you believe the properties have been zoned for commercial or industrial development?
I'm sorry, Your Honor, this is far outside the scope of Mr. Yowell's testimony.
No, Your Honor, with all due respect, Mr. Yao testified that these properties were purchased for investment purposes. He's now told us they were purchased for quote unquote development as that occurred. I asked him if it was for residential development, and he said yes. And now he's offering testimony that it's somehow a commercial or industrial potential for the property, and I'm exploring that.
And
In the context of these properties being quote unquote investment properties.
this is a fair question. Mr. Yao can't have it both ways.
Excuse me.
Well,
Excuse me.
well,
No. Hold up.
Sorry.
Mr. Yeager, no,
Yeah.
I'm not going to entertain other counsel's, comments on this. Is an objection between the applicant and Mr. Drummond. I will
So other
allow,
parties can't weigh in on an objection, an
Not-
argument objection?
not this one. No, it doesn't. When it's your turn, you can handle your objections on your testimony.
You know, the court
I can
proceeding.
handle, I'm sorry, sir. I can handle this objection. I'm going to allow Mr. Drummond to ask a few more questions in this area. Limited in scope. Please proceed.
So my question was, Mr. Yao, how long do you believe the it's actually two parcels, have been zoned to permit commercial or industrial development?
Let's see. I married into the family in 1994. And before then, I don't know when before then, but when I came into the family, they were already zoned that way.
I believe they continue to be zoned to allow that sort of development.
The part of the farm is zoned that way, correct?
I have any other questions? Thank you.
Good morning, Mr. Yao. This is Mr. Yeager, county attorney. I have the county zoning map in front of me. Would you be surprised to know that no portion of this property is zoned industrial?
Again, Your Honor, I have to object to this. This is outside the scope of Mr. Yowell's pre-filed direct testimony. These were questions about the county zoning map, about its ordinance. Mr. Yowell does not testify on that point.
Mr. Yao testified that this property was zoned industrial and the portions of this property were zoned industrial and allowed industrial development.
Mr. Yeager, do you have a witness that can introduce the zoning map?
I do, but I think it's a fair question for Mr. Yao, and it's a fair.
If he's mistaken, sir, your exhibit will show that. Okay,
but
can we move on? This is a very limited, I don't even see how important this is. Okay.
I have no other questions for Mr. Yao.
Okay. Mr. Hicks.
Thank you, Your Honor. Or Mr. Yao. I just want to speak with you about the contracts that you have with developers. Do you recall what years or specific dates that these contracts were entered into with the developers?
Okay, I mentioned that there were two developers and that I came into the family in 1994. Prior to my coming, there was a contract with a developer that was going to build a golf course and residential community. But that was just in conversations that I've had with my father-in-law. And he showed me the plans that were drawn up for the golf course and the housing development. So I know that that existed, and he told me that the town had not wanted to annex the property, so it never happened. That's my only knowledge about that first one.
Let me just clarify really quick, because you said it was prior to 1994.
Mr.
Are you
Hicks,
referencing?
Mr. Hicks, you're speaking too loud. Could you speak a little softer, please, and a little slower?
Yes, sir. Is that contract for the golf course one of the two contracts you referenced in your direct testimony?
Yes. The second one was in 2006, and it was the Passon family from Easton that had a one-year contract. And I was at a town meeting when the Passons and their attorney asked to have the property annexed, and the town voted to against it. So that was the second time. That was our second contract. And then the Eastern Shore Land Conservancy, who we've always been supporters of. The family has been very supportive of the Eastern Shore Land Conservancy, came to us and wanted to try to develop the property in a way that their philosophy was that all development on the eastern and northern Eastern Shore should be near a town center to keep more farmland. So they were in favor of developing this property. And they spent a year, the year 2007, trying to get it passed. They did a lot of work with the county and tried to get a lot of local support. And the town, Chestertown, was not interested in annexing the property, even with their presentation. So that's the last group that was interested in residential development on the property.
Do you recall when that was?
2007.
And since then, you have not approached the town about further residential development?
We have not, no. We're not in that business.
Thank you, Aaron. That's all I have.
Thank you. Any redirect?
I have no questions, Your Honor.
Okay, thank you, Mr. Yao. You may be excused.
Thank you very much.
Mr. Bugelmans?
Thank you, Your Honor. Next, we would like to call Mr. Thomas Wygrand. See his video popped up there.
Yes, Your Honor, I'm here.
Good morning. Can you please raise your right hand? I think that's your left. Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. And Mr. Bugelmans, do you have an attestation?
I do, Your Honor. I hereby attest that the witness is alone in a separate room and not in communication with any other individual.
Thank you. Please proceed.
Thank you, Your Honor. Mr. Wygrand, can you please state your name and provide your business address?
Yes, Thomas Weigand. Last name is spelled W-E-I-G-A-N-D. Business address is 1 Annapolis Street, Suite 202, Annapolis, Maryland, 21401.
And what is your company and title?
The two-member LLC that owns the company is Carolex LLC, and we trade as Treffer Appraisal Group.
Thank you. Do you have before you a document entitled Direct Testimony of Thomas A. Weigand, MAI, dated August 2nd, 2019, consisting of 65 pages inclusive of attachments?
Yes, sir, I do.
Your Honor, I'd like to request this document be marked for identification as applicant exhibit 18.
So marked.
Mr. Wygan, was this document prepared by you or under your supervision and control?
Yes, sir, it was.
If we were to ask you the same questions today, would your answers be the same?
Yes, sir.
Is your testimony true and correct to the best of your ability?
Yes, sir, it is.
Thank you. With that, Your Honor, I'd request to move applicant exhibit 18 into evidence.
Any objections? Hearing none, applicant exhibit 18 is entered into the record.
Thank you, Your Honor. And with that, the witness is available for cross-examination.
Mr. Drummond, do you have any questions for this witness?
No, I don't. Thank you.
Mr. Yeager, do you have any questions for this witness?
I do
Mr.
not.
Thank you. Mr. Hicks, do you have any questions for this witness?
Briefly, Your Honor. And am I still speaking too loudly?
You're fine for me. Thanks.
That's fine. If you can keep that up, that would be great.
Thank you, Mr. Court Reporter. Mr. Wygrant, so you did a obsolescence study. Am I saying that correctly?
Obsolescence, Mr. Hicks.
Obsolescence. Thank you, Mr. Wygrant. And as a doctor, I apologize.
No, just
Okay.
Mr. Wygan or Tom is fine.
Thank you, sir. I just want to clarify some things. You first started with every solar farm over 1 megawatt, correct?
Yes, sir.
And then jumped to 2 megawatts, and that's for Maryland, correct?
Yes, sir.
All right, and then 10 megawatts in Virginia and Delaware.
Yes, sir.
And 20 for Virginia and Delaware. Why would you go those megawatts for each state?
Those were some of the data thresholds that I had when I looked at the various databases, and there were many 1 megawatt locations in Maryland, and I knew I would still have a fine data set if I just raised that threshold to 2, and then going out of state, I was looking for larger megawatt installations that did not exist necessarily in the state of Maryland.
Okay. For Maryland, in the study, I think overall, the largest solar farm you studied was 14 megawatt. Is that correct?
Yes, I believe that was the one. Yes, that was the one in Worcester County.
Okay. And were you just not able to find a solar farm in comparison to 45 megawatts, the size of the one planned here by the applicant?
That is correct. Yes, sir.
Okay. As far as 45 megawatt, is that one of the larger solar farms potentially in the state of Maryland?
Yes, sir. It's one of the larger ones that I have reviewed or are aware of.
Okay. I'm not going to go through every single sale that you did, but would it be correct in saying that it was somewhat of a neutral finding as far as home sales near a solar farm, home sales away from a solar farm?
Correct. Yes, sir.
All right. And you, in your report, you actually conclude that you can't make any consistent finding, correct?
Correct.
So basically what you're saying is you can't determine whether or not there would be a positive impact on home sales or negative impact on home sales regarding the 45 megawatt solar panel farm.
I think, sorry, I think my conclusion is no impact based on the data that I reviewed.
Right. So your conclusion was that it wouldn't have any impact, but in your direct testimony, but in your, if I may, your conclusion in your report was that there was no consistent finding.
Mr. Hicks, I'm referring to page 1 of my report, which is the bottom of the executive summary, and there's a sentence typed in bold. The values of properties in proximity to solar farms are not impacted by the proximity of the solar farm.
Okay. But your testimony just was that you couldn't determine whether solar farms based on the study had a negative or positive impact because of how neutral they were.
Yes, sir. Expanding on that, the data that's summarized at the back of our report speaks for itself, and I cite the median property differences and mean property differences ranging in the 1 to 2% range, which would be not skewed in any one direction to reach a firm conclusion of influence.
Right. You can't reach a firm conclusion of influence.
Based on the fact that I didn't see the data skewing in one direction or the other, I concluded, and considering the range of percentage differences, I concluded with the sentence on page 1 saying no influence.
Okay. I'm referring to page 41 of your report.
Yes, sir. I had that page open.
Okay, and it says, my analysis shows that solar farms have no consistent impact on surrounding property values.
Yes, sir.
But then your conclusion is that it does not impose any form of depreciation on adjacent residential properties.
Yes, sir. Because of the lack of the data going in one's direction or the other, a clear indication of appreciation or depreciation, that's what led to my conclusion of no effect. Yes, sir.
Wouldn't it be true that if there was no consistent impact, that you wouldn't be able to say that it depreciates or appreciates the adjacent property values?
I'm not sure why someone would, if someone probably could conclude that. I'm not sure why. It's clear to me, looking at the 19 sales that I looked at, that you know, we do not have a influence on property values.
Right, and what I'm saying is your study shows that you can't tell whether it would be an appreciative or a depreciative impact on those housing values.
I'm sorry, Your Honor. The witness has answered this question 5 times already.
May I respond, Your Honor?
He has answered it. I'll allow the witness to try and help Mr.
I guess what I'm
Hicks
trying to
out.
get at, Your Honor, if I may, maybe my question is confusing. In his conclusion, he says that it wouldn't have a depreciative effect in the direct testimony, but in his conclusion, his report is that he can't say what consistent impact it was. So what I'm trying to get at is, how can he say that there wouldn't be a negative impact if he doesn't have enough data to ascertain whether it would be appreciative or depreciative?
Okay, I'm not sure that's what he said, but I'm going to give the witness a chance to clarify.
Thank you, Your
Honor. Sure. I think I understand the question, Mr. Hicks. I don't know anywhere in the report where I say I don't have enough data to support a conclusion. Now, I am summarizing the data on the table on 41, and my first sentence at the bottom of that table says that the numbers are not trending. They're not consistently, is the word I use. There's no consistent impact on surrounding properties. The data is not trending in one. There's no market evidence of a positive impact. There's no market evidence of a negative impact. Therefore, that sentence is an interim sentence or an interim consideration as I make the final conclusion on page 1 of no impact. But I don't think it's an absence of data. I certainly apologize if that's not clear on this page. It's an absence of direction from the market. The market's not saying these sites are negative. The market's not saying these sites are positive.
Okay, I think I understand now, and I think we've exhausted this line of questioning. Do you have any more questions?
No, Your Honor, that was helpful. Thank you. I have no
Mr.
further
Bugum-
questions for Mr. Plugin.
Okay. Mr. Bugelmans, any redirect? Thank you, Mr. Wiggand. You are excused. It's a little early, but I think it probably makes sense to I'm going to mute you for a second, Ms. McLemore. Makes sense to take a break. But yeah, Ms. McLemore, did you want to speak?
Yes, Your Honor. If we could possibly go ahead and take Dr. Hall at this time, it would be very helpful.
Okay, we can at least get started. And we'll see how far we get before we have to take. Is that fine with you if he gets interrupted?
I'm sorry, Your Honor. Could you repeat your question?
I'm certainly fine with as long. Okay, I'm going to mute you while I answer. So long as Mr. Bugelmans doesn't object, which I don't think he's going to, I'm fine with proceeding with Dr. Hall out of order. My concern is the length of his testimony will be such that we will have to break in the middle of his testimony because people will be hungry. If that's fine with you, I'm willing to get started now. You have to unmute.
Your Honor, he has to be completed. He has to be able to go at 1 o'clock, is my understanding.
Okay, let's get started.
There he is.
Let's get started and see how far we get.
Thank you, Your Honor. Thank you, Your Honor.
Dr. Hall, can you raise your right hand? Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
And Ms. McLemore, do you have an attestation for me?
Yes, Your Honor. Apologies, we were having some problem with the volume. Your Honor, just give me 1 second. I'm trying to find it.
Certainly.
Certainly.
Yeah, you need to turn yours down.
Yeah, you need to turn. Your Honor, at this time, I do attest that the witness that Dr. Hall is alone in a separate room and not in communication with any other individual at this time.
Okay, thank you. Please proceed.
Okay, thank you. Indeed. Dr. Hall, at this time, Your Honor, I apologize. I don't know. Has Dr. Hall been sworn in yet?
Yes, I did
I had
swear.
a problem with my. Yes, I did swear. Okay, thank you.
But can you, Ms.
Dr.
McLemore,
Hall.
can you turn down your volume on your computer?
Okay. On your computer.
I really don't like hearing my own voice back
Really
at me.
don't my own voice back at me. Okay, can you hear me now?
Yes.
Yes. Okay, it is completely up.
But I
Just
also
let me
hear
know
me.
if you can't, and I'll get out. I'm sorry?
I also hear myself.
I also hear myself.
Your Honor, I'm getting your voice.
Your Honor,
Your Honor, I'm getting your voice twice.
Do you want me to test it again, Your Honor?
No.
No. Are we good?
No. Someone's volume is so high that we're getting an echo.
We're getting an echo.
The other option.
I turned mine down. Is that
the
better?
other option? No. Hang on.
No.
Let me. Okay, I muted Dr. Hall.
Okay, I muted.
No, that's not it either.
No, that's not it either.
Ms. McLemore, you're going to have to.
Ms. McLemore,
Yeah, you're going to have to mute yourself whenever you're not speaking.
Whenever you're not speaking.
So you're going to have to keep your finger on your mouse and mute and then unmute when you're speaking and remute constantly. Okay?
All right, Your Honor.
All right. I'm going to unmute Dr. Hall. Okay, he should be. Dr. Hall, are you able to unmute yourself? Yeah, okay. You should be good to go now. I did swear him in. Please proceed.
Thank you. Thank you, Your Honor. Dr. Hall, could you please state your name and business address?
My name is Peter Douglas Hall, 455 Old Hollow Road, Sperryville, Virginia, 22740. I operate under the company name Metametrics.
Your Honor, I apologize. I'm having a lot of problems with being able to hear Dr. Hall. Could you give me 1 minute and let me see if I can get on another computer that might be more helpful?
Sure. Do you need a few minutes? We can take a break.
Thank you, and I apologize. I don't know what's going on.
Okay, we'll be in recess for approximately 5 minutes. Do we want to do a sound check, Ms. McLemore?
Thank you, Your Honor. Can you hear me okay?
That's fantastic. No echo, nothing.
Your Honor, this is Doug. I'm ready when you are.
Thank you. Ms. McLemore, just let us know when you're ready.
I'm ready, Your Honor.
Okay, if we can go back on the record.
Dr. Hall, do you have before you a document entitled The Direct Testimony of Peter D. Hall, which is dated December the 17th, 2019, consisting of 14 pages and 2 appendices?
I do.
And at this time, Your Honor, I'd like this to be marked PPRP Exhibit 1.
It was pre-marked as 15.
Yes, Your Honor. I didn't know if you wanted me to take it in the order that we provided it. The things have been turned around now, so
It
however
might be
you want me to-
easiest to just stick with your pre-filed.
Perfect. At this time, Your Honor, I would like this exhibit to be marked PPRP Exhibit 15.
So marked.
Dr. Hall, was PPRP's Exhibit 15 developed under your supervision or control?
Yes, it was.
And if I were to ask you the same questions today, would your answers be the same?
They would.
Your Honor, with that, I would like to enter exhibit number, PPRP exhibit number 15 into the record.
Any objections?
Yes, Your Honor. Chris Drummond on behalf of Kent Conservation and Preservation Alliance. Dr. Hall refers to himself as a consulting economist who specializes in regional economics and socioeconomic impact analysis assessments. We are not provided in his testimony with the background that gives him that alleged expertise. Moreover, his testimony is replete with assumptions and opinions well outside the professed expertise.
Okay, well, Mr. Drummond, those will be questions that you'll ask him then, okay? I'm not going to exclude his testimony at this time on that basis. Okay, we're going to...
And for purposes of the record, that typically when opinion testimony is offered and admitted, there needs to be an established expertise to form the predicates for that for those opinions.
Yeah, right. Mr. Drummond, I'm not admitting it right now. I'm going to allow you to ask him your questions about his experience. Okay, it was
watching it right now. Okay.
Okay. So
thank you.
Do you want to proceed with his, Ms. McLemore, do you want to proceed with his second exhibit? And then Mr. Drummond will maybe have the same questions with regard to that one.
Of course, Your Honor. Dr. Hall, do you have before you a document entitled Reply Testimony of Dr. Peter D. Hall, dated March 20th, 2020, consisting of 14 pages and exhibits A through F?
Yes, I do.
Your Honor, at this time, I would like to have this exhibit marked as PPRP Exhibit 16.
So marked.
Dr. Hall, was this exhibit developed under your supervision and control?
Yes, it was.
And if I were to ask you the same questions today, would your answers be the same?
They would.
Your Honor, at this time, I would like to enter exhibit number
16, PPRP exhibit number 16 into the record.
Same objection, Mr. Drummond?
Same objection.
Okay. We'll proceed with Mr. Drummond's cross-examination of this witness at this time.
Dr. Hall, my name is Chris Drummond. I represent Kent Conservation and Preservation Alliance. Dr. Hall, do you have any experience in land use planning?
No, I do not. I am not a certified land use planner.
Have you ever been involved in the preparation of a comprehensive plan on behalf of a county or town in Maryland or any other state?
No, I have not.
Are you a landscape architect?
No.
Are you?
Mr. Drummond, his testimony lays out his experience. Can we get to some relevant questions about his experience?
Questions I'm asking, Your Honor, in as much as
That don't have anything to do with his testimony.
they most certainly do, in as much as he opines in his reply testimony regarding the land use elements of the county and town's comprehensive plans and how they're not likely to be affected by this project. He refers to the landscape plan as effectively screening the project from 291 and other views. And that the, so it seems to me it's entirely relevant to whether or not he can opine on those subjects.
Yeah, I'm not certain. So can we move it along to some substantive questions?
Other questions I would have is to the admissibility of his testimony, which
Which you didn't object to when it was filed, correct?
No.
Okay.
It wasn't offered in evidence when it was filed.
I understand. Do you have any more questions for Dr. Hall?
I think I'm being instructed not to ask anymore, so I don't have any more.
No, what I was asking you to do was ask questions that are related to his testimony.
Yeah.
I was gonna ask, are other parties allowed to weigh in on this issue?
Did you make an objection to his testimony coming into evidence?
No, but I'm objecting now. I mean,
wait a minute.
Mr. Drummond
Mr. Yeager, did you object to his testimony coming into evidence? You didn't, right? You just said you didn't.
I didn't, but what I'm
And you're not allowed to help counsel. He's counsel for the party that objected. You're not going to piggyback on and try to be his co-counsel. We're not doing that.
But we have the same position in this case.
No, you didn't raise an objection.
Well, maybe he just didn't get to it before I.
No, Mr. Drummond, he said he didn't object. We're not doing this, Mr. Drummond.
Supposed to be a fair hearing. I mean,
Mr. Yeager, you didn't object to this document coming into evidence. Mr. Drummond did. Mr. Drummond, proceed.
Thank you. And Judge Lawrence, let me read an example of what concerns me about Dr. Hall's, the limits of his expertise.
Hang on, hold up. Miss McLemore?
Yes, Your Honor.
Are you offering Dr. Hall's testimony as expert testimony in this case?
I'm offering it as testimony of a consultant that's been working on siting generation sites in the state of Maryland for some 25 years.
Okay. Mr. Drummond?
And Your Honor, to the extent that they have, they would like some testimony stricken or not included in the record. If they could be specific as to where they are talking, it would be very helpful.
Yeah, I'm trying to get to that point, but we have a lot of general questions. Okay, Mr. Drummond. I think he testified that he's not a landscape architect.
Use planner. And Dr. Hall, in your reply testimony, you analyze what you referred to as land use constraints. Is that correct?
Can you
Yes,
direct
could
him?
you
Could you perhaps direct him to where in his testimony for all of us?
Page 3, line 16
Thank you.
of the reply.
Yes, I did.
Thank you. On page 4, line 13, you, as I understand it, accept the quote unquote 20 plus megawatt benchmark postulated by Morgnec Road Solar. Is that correct?
No, I did not.
If you look at page 4,
I
line
said-
13.
That was in response to the applicant saying that a utility scale solar is 20 plus megawatts. And so I singled that out in conclusion. But I also looked at unoccupied parcels that have developable acreage that can support a 10 megawatt or larger solar project.
That's not my question. My question is, Dr. Hall, are you, is your experience and your educational background such that you can opine on whether or not the 20 megawatt benchmark has any significance in the development of solar projects?
I did not opine on that.
I want to, on page 8, you provide us with your opinion about the extent to which the proposed landscaping will shield the project from Route 291. Is that correct?
You may point me to the statement, please.
In the middle?
You begin with line 14.
Correct.
And where I said the applicant has stated the top edge of the solar panels will be 8 feet above ground level.
That section there, and you, do you strike that?
So what was your question?
Simply repeating what the applicant said, Dr. Hall, or are you adopting the applicant's postulate that this landscaping will shield the project from Route 291?
I'm not adopting the applicant's position there.
It is in the context of whether or not you agree with the intervener's view. If you look at the top of the page, impacts to view sheds and cultural landscapes. The question was put to you, do you agree with the intervener's position that the project will impact views? So you're rendering an opinion that it will not, based upon this applicant's landscaping plan. Am I correct?
I answered yes on the first sentence, and I qualified it.
And you do not have you do not have a background in landscape architecture or landscape design.
No, I do not.
Okay.
So, Mr. Drummond, am I to understand that you'd like this portion of Dr. Hall's testimony stricken because he doesn't have a background in landscape planning?
Yes. If we're going to if you're going to admit parts of the exhibit and
We're certainly not
others,
going to not admit the entire document. No. So
that would certainly be the answer to the question at the top of page 8 should be redacted.
that is your position.
That's right. That's correct, Your Honor.
Do you want to redact the question that says witnesses on behalf of interveners testify that the proposed project will impact the views from Maryland 291 and other locations near the entrance to the town of Chestertown? Do you agree? You want
I
that
do.
question stricken?
An answer stricken because it is includes opinion testimony
That you believe requires background in landscape planning. Right? Do I have it right?
So
I'm
are you
sorry.
also saying that the interveners here have
Dr.
also
Hall,
testified?
Dr. Hall, can you please hold on a minute? Mr. Drummond, do I have your objection completely? Mr. Drummond?
Yes, I'm sorry. I thought you
I just
didn't.
want to make sure I have your
Yes.
objection. Because he doesn't have a background in landscape planning, you would like this answer stricken. Okay, that request is denied.
You're,
Dr. Hall, what is your experience or knowledge in the presence of hedgerow plantings in the surrounding agricultural landscape of Kent County, as you set forth on page 9, lines 16 through 18?
Repeat the question for me, please.
What familiarity, if any, do you have with hedgerow plantings in the surrounding agricultural landscape of Kent County?
Well, I've been involved in at least three other cases in Kent County for the development of solar facilities. We have evaluated them in the context of existing views.
I would move then that's not responsive to my question, nor does it provide a background, any basis for knowledge to render an opinion such as he does in response to
the lines you directed us to, I believe, were Ms. Watson describes witness Ryang's hedgerow landscape buffer design, which attempts to replicate hedgerow plantings in the surrounding agrarian landscape as a wall of unnatural proportions. Then in line 19, Dr. Hall testifies, I do not disagree with Ms. Watson's testimony regarding the characteristics of this landscape. However, I would note that creating a mixed-use development on the subject property, as Ms. Watson advocates on page 31 of her testimony, would not preserve the landscape. So which portion of his testimony do you wish to have stricken?
whole thing, as he does not have the requisite background or knowledge or expertise to render any such opinion. It's gratuitous, in other words.
No, I'm trying to find where you find an opinion that needs to be stricken. He says, however, I would note that creating a mixed-use development on the project property, as Ms. Watson advocates on page 31 of her testimony, would not preserve the landscape. That's the opinion you'd like stricken?
Yeah. Well, what else is it but an opinion?
And that's based on your argument that he doesn't have familiarity with hedgerow plantings in Kent County?
Have specific experience with that. He doesn't have a background in land use planning. He's not a landscape architect or have experience in land use design. He doesn't know what a mixed use project may or may not produce by way of screening. It's gratuitous, and I understand it supports PPRP's position, but that's all it does.
Okay. I will strike the sentence. However, I would note that creating a mixed-use development on the project property, as Ms. Watson advocates on page 31 of her testimony, would not preserve the landscape. I will strike that as gratuitous, but that's all I'm going to strike in that portion of his testimony.
All the questions I have on voir dire. Well,
Okay, other than that, then that one sentence, lines 20 through 22 on page 9 of Dr. Hall's testimony that I struck, that exhibit 16 will be entered into the record. And in case it wasn't clear, exhibit 15 is entered into the record. Do you have more questions, Mr. Drummond?
yes, thank you. Dr. Hall, is it your position that a town such as Chestertown may expand its population only in accordance with population projections emanating from the Maryland State Planning Department?
No, it is not.
So if a town such as the town of Chestertown decided that it wished to grow at a faster rate, or identified an opportunity to grow at a rate other than population projections, that it may take steps to do so?
I'm not sure how towns choose to grow, Mr. Drummond.
That's because you don't have any expertise in land use planning, is that right?
Yes, I'm quite sure you would say that.
Well, it's true, isn't it?
No, it's not true.
So towns can't
You know
choose
that the
how they wish.
population projections in Kent County in their comprehensive plan were based on 2004 and 2007 studies.
Those studies,
And
I'm sorry.
and those projections failed to follow actual populations since that time.
Have you studied, Dr. Hall, how, if at all, the COVID-19 pandemic may affect shifts in population growth?
Personally, no.
Okay. Have you examined how, if at all, the migration of population from more densely populated areas and the rising cost of housing might increase migration to more rural areas?
Not for this project.
You are aware, I take it, that the project as proposed will consume the Clark Farm for at least 30 years?
Yes, I'm aware of that.
And if the settlement agreement is adopted as the applicant / PPRP settlement agreement is adopted, that could be upwards of 34 years. You're aware of that?
Yes, I'm aware of that.
And that the whatever changes there may be in the migration of population for more densely populated areas to more rural or suburban areas will not be able to be accommodated at all around in this area near Chestertown for the next 3.5 decades.
Well, I must admit that this property is not the only growth area in Chestertown. And the comprehensive plan for the town also noted that there was capacity within town for several thousand additional residents. So I'm not sure, you know, what the relevance of your question is.
Have you examined the availability of developable properties in the other planning areas around Chestertown shown in the town's comprehensive plan?
I believe I did. I don't see where in my testimony where this might be, but
Dr. Hall,
if
then,
you go up to page 5, line 28, you'll see that the town's own comprehensive plan estimates nearly 7,000 residents could be supported within its 2015 municipal boundary. Now, this is a town with a population of 5,000.
Well, you didn't answer my
So we're
question.
talking about more than doubling the population.
Answer my question. My question was whether you investigated whether the other planning areas outside the boundaries of Chestertown, I've lost my train of thought, whether you investigated the areas available for additional development, residential and or commercial or mixed use development, in the planning areas around the town of Chestertown other than the northeast planning area.
I believe that is in the PAR that accompanies my testimony and the testimony of other contractors.
How many acres of protected land are there in the other planning areas, whether protected by easement, malfeasements, MHT easements, and so on in the other planning areas? Do you know?
I'm not sure I can tell you what the easements are. I can tell you that of the 7 areas, which is more than 1,500 acres, they have a capacity of 2,600 residential units. That is from the town of Chestertown's comprehensive plan.
Dr. Hall, how many of the undeveloped lots to which you refer within the town of Chestertown are, for all intents and purposes, someone's side yard or backyard? Do you know?
I doubt if any of them are.
Don't. The answer is you don't know.
Those areas are empty areas.
I don't know, Dr. Hall, maybe we're not saying the same thing to each
I
other.
don't think we are.
I'm asking you about the so-called infill lots in town to which you've referred. And I'm asking you how many of those so-called infill lots to which you've referred, you didn't refer to them as infill lots, but the in-town lots that are not improved, how many of those are for all intents and purposes, the side yards or backyards of residentially improved property?
So you're talking about whether they are within the property lines of um, residential units there?
I'm asking you whether a house is built on lot 1 and whether the owner of lot 1 also owns lot 2 and likes it as his or her side yard.
I doubt if it's very high, quite frankly. I
Don't
don't
know.
have the number with me.
Dr. Hall, I don't know whether you have the background or experience to answer this question, but I'll ask it anyway. Do you know why lots go unimproved over long periods of time in towns?
Sometimes for speculation, but
Your
I'm
Honor,
not going to guess what every person in the world doesn't improve a lot.
Your Honor, I'm
other
going to have
words,
to object to relevance. I don't understand how this is really relevant to what Dr. Hall has testified as to.
Oh, it's entirely relevant as Dr. Hall, and we're soon to hear from Joe Stevens, testify that there's all these unimproved lots in Chestertown, and Chestertown can meet all the possible population increase projections by developing all these infill lots. It's a fantasy, and I'm trying to explore why that is a fantasy.
Your Honor, I would like to, I don't understand exactly where you're talking to. If you could point to, if counsel could point me to where exactly Mr. Hall, Dr. Hall says that there's all these lots in Chestertown?
You actually,
Testify,
hang on.
excuse me.
It would be helpful if you could point to where in the testimony you're getting your information, but also your question was whether he had the expertise to answer a completely speculative question. So it was completely improper. So you're going to have to reword or rephrase or something with that question. But if you could point us to where you're trying to, elucidate more information, that would be helpful for everyone.
Lawrence and Ms. McLemore, I'm not referring to his testimony, written testimony. I'm referring to his spoken testimony about 10 minutes ago.
And then I think you've not stated it correctly.
Dr. Hall, in your analysis, did you rely at all upon the lots that are unimproved within the town of Chestertown to conclude that Chestertown may meet population projections over the next decade or so?
No, my primary source of reference was the Chestertown Comprehensive Plan, the Kent County Plan, and state data.
Donna, can I just interject just a clarification? Did you say, Dr. Hall, the comprehensive plan, the state plan, and you said something data? I didn't catch the something.
Well, it was just state population projections and other data that are regularly published by the Maryland Department of Planning.
Mute, Judge Lawrence. I think you're on mute.
Thank you. What Dr. Hall just referred to, I'm seeing on between pages 5 and 6 of his testimony, if that's helpful for anyone, Mr. Albert. Okay, Mr. Drummond, do you have a question? Are you shaking your head? You don't have a question?
I don't have any question.
You don't have any more questions for Dr. Hall? Okay. Mr. Yeager, do you have any questions for this witness?
Yes, Dr. Hall, did you take into consideration the fact that Chestertown is bordered by water primarily on its south side in looking at growth?
Well, I certainly took into account that there's the Chester River and the south and the bay to the west. Yeah.
And did you take into account that in the areas primarily on the west, southwest of Chestertown are permanently protected land and as such cannot be developed?
Yes, I did.
And you took into account as well, I take it, that on the northwest side of Chestertown, the land that borders the northwest side is permanently protected and cannot be developed.
I took all land use constraints into account.
Right. And I take it then you also took into account that on the east side, the northeast side, where this property is located, this property is not protected and could be developed and annexed into the town for development, for growth. Unlike those other properties.
You're talking about the septic property?
Yes.
Yes, I recognize that.
Right. Now, sir, would you be surprised to learn that I live in Chestertown and my wife and I currently own the unimproved lot that's next to the lot where our house is, and we use that lot as our yard? Would that surprise you?
No.
And would it also not surprise you that our next door neighbor owns the unimproved lot next to their house, and they use that unimproved lot as their yard as well?
I'm not surprised.
And would you agree with me that in town, when you have common ownership of two adjacent lots, one improved and one unimproved, that it's unlikely that those lots are going to be developed because the homeowners treat those other lots as their yard?
I'm not going to speculate on that. I don't believe that you're going to necessarily own that house for the next 20 years, for example.
Well,
somebody would look at that property and they say, there we go, I've got a house and an extra yard.
Right.
I'm going to sell that, make some money. Why not?
And chances are the house is going to be more valuable if you have the yard that goes with it. All right, I have no further questions for the witness.
Are you withdrawing that last question?
Yes, he didn't answer it, so I'll let him answer the question.
Dr. Hall, do you remember the last question?
Somebody has a phone.
No, I don't remember it.
Somebody has a phone ringing. It's kind of distracting. I don't know if others can hear a phone ringing.
Yes.
All right.
Dr. Hall, I'm sorry, I muted you because of the ringing phone. Can you, if the phone is finished ringing, can you unmute yourself?
All right, I'll withdraw the last question. I have no further questions for this witness.
Okay, Mr. Hicks.
Thank you. And I understand Mr. Hall has to leave in about 5 minutes. Is that correct, Mr. Hall? Dr. Hall, excuse me.
No, go ahead and ask your questions.
All right, thank you, sir. I'll keep it brief. In your reply, you stated that you investigated other parcels of land in Kent County for a potential solar farm.
Yeah, you point me to the page, please.
Yes. I believe it starts on page 2. You describe each parcel going down through page 4. You see it?
Yep.
Okay. just want to clarify something. You say only 2 parcels in Kent County are zoned for utility scale solar using the applicant's 20+ megawatt benchmark. Is that 2 additional properties or this property and 1 additional?
No, it would be 2 additional.
Okay. And you say that citing a 45 megawatt capacity among those 2 parcels, so there's two other possible areas. The only issue with those is they would change the financial fundamentals of the project.
Well, there might be other things that are of concern. There may be opposition for various reasons. I didn't get into that detail to say whether they were going to be acceptable.
But based upon your
Financially, if you split a 45 megawatt solar facility in half, you're definitely going to change the parameters cost wise.
correct. Those 2 parcels, though, those additional 2 areas that could potentially have a 45 megawatt solar farm, those are properly zoned for a solar farm?
One moment. Well, first of all, I think I said that no parcel can accommodate a 45 megawatt facility. But all the parcels I looked at, they are unoccupied, and the 220 plus were zoned for utility scale solar.
Thank you. So is it your finding that there were 2 additional locations that this solar farm could potentially be within Kent County?
No, not a 45 megawatt, no.
So I'm looking at page 4, lines 12 through 16.
Yep.
Excuse me, I see it now. And no parcel can accommodate. You say no parcel. Is this including the site plan right now?
No, I did not include that one.
Okay. I have nothing further, Your Honor.
Any redirect, Ms. McLemore?
Sorry.
Ms. McLemore, you muted yourself at some point.
Let me.
You're off.
All right. Thank you, Your Honor. Dr. Hall, could you please summarize your educational background, your relevant educational background?
I have a BA in geography. I have an MA in economic geography, which is regional economics. I have a PhD in transportation planning at the MIT. I've been working on siting for the state of Maryland since 1980 and have worked on more than 200 projects over that time.
Do you know approximately how many of those projects relate to generation projects? Approximately.
Well, the majority, I'd have to say, probably 200.
And what do you look at when you say that you review them? What is it exactly that you look at, you review in these cases?
Well, we review the economic and fiscal impacts of the project, land use impacts, transportation impacts, visual impacts, public safety, property values, anything that may be in particular to that project, whether it be, water transportation, anything that in the environment that could be affected, we look at.
And in that experience, have you reviewed comprehensive plans?
Pretty well every one.
And in your experience, in doing these reviews, have you reviewed land use?
Yes, I do.
And in your reviews, have you done any photo simulations?
Yes, I have.
Can you know approximately how many?
Photo simulations, which are a little bit different than what we did in this project, probably, up to 20.
Okay, and could you please describe how much literature in this area with regard to the impacts of solar, utility scale solar, have you reviewed?
More than 1,000.
And with regard to renewable generation plants that have applied for a CPCN application, do you know approximately how many you've worked on?
Probably 30 to 40.
And how many of those approximately were solar?
Let me say 30 to 40 solar and probably 45 to or 10 to 5 to 10 would be wind. I'm not counting nuclear here, and some hydro.
Are you aware of any utility scale solar project in the state that has applied in the last some 15 years? I think it's been about 15. Are you aware of any that you have not reviewed, been involved in the review of the socioeconomic impacts of it?
Nothing over 2 megawatts.
Thank you, Your Honor. I have nothing further.
Dr. Hall, you said something about conducting 20 photo simulations, but that's a little bit different than what you did in this case. Can you elaborate?
Well, photo simulations, what you do is that you draw proposed landscaping on a photo to give what the viewer's impressions are of what the view of a project would be from a particular point of view. For this project, and for most of the solar projects, we rely on visible area analysis. And that takes a very comprehensive view of a project, taking terrain relief and forest cover into account to see where a project is likely to be visible both without a buffer and with a buffer.
Okay, and that's what you were referring to on page 12 of your direct testimony when you referred to a visual impact assessment?
That's correct.
Okay. Any questions based on my questions?
Dr. Hall, in your visual impact assessment of the property proposed for this 45 megawatt solar project, did you assess the ridge that exists on the property in an east-west direction north of 291?
Yeah, that would have been part of the, the terrain elevation that's taken into account.
If any conclusions did you reach about the extent to which the solar project would be visible once constructed on that ridge?
Well, I think my conclusions were that views of the project within the perimeter fence would be limited if the buffer matures as expected.
Include
and that,
the,
of course, is the if.
You did not consider doing a photo simulation of the landscaping as proposed with respect to the panels on that ridge?
No, I did not.
Oh, the highest elevation of that ridge?
No.
And in photo simulations, it's my understanding that in part, one of the things that a person does is, looks at ground level, you have intervening landscaping, and there's sort of a cone. And you extend the cone out to see whether the cone, that is the cone, the top part of the cone intersecting with the top of the landscaping, what you can see beyond the landscaping. Is that a technique that would be used?
It might be. I don't know.
Is that something you use?
On some cases, I do look from perspectives around the site that would indicate which components might be visible even with the buffer.
This circumstance is correct me if I'm wrong. Your testimony reveals that you assumed only the height of the panels at about 10 feet, I think you said. Correct me if I'm wrong.
No, I assume the height of the observer.
I hadn't gotten to that point yet. Yeah, the height of the observer on the road and the height of the panels at their highest point of rotation, I suppose.
That's correct.
Which was about 10 feet, I think you said.
It was 8 feet.
8 feet. And that was on a plane relatively consistent with the plane of the observer.
The top part of the panel?
No, the plane on which the panels are constructed, it was relatively consistent with the plane of the observer, which would be 291, Route 291.
No, not at all. We take the actual elevations of land within the project property, which in this case ranged, well, I can't remember, but anyway, and then we put the panels on top of that surface. So we do put, if there are panels on the ridge, they would be at a higher height than panels down near the road.
And what simulation did you perform to conclude that if you did so conclude, that the landscaping as proposed will shield the panels on the ridge?
I don't think I singled out the ridge in my particular analysis. Some parts of the project will be visible, but my conclusion was if the landscape matures as expected and the planted materials remain in good health, views of project components will be limited.
What is your, over what time period do you understand that landscaping will mature to a point where it limits the view of the panels on the ridge?
Well, typically we assume a landscape buffer matures after 5 years. In this case, we required that the perimeter fencing have be clad to block views until the buffer matures.
Fence is 7 or 8 feet tall, right? Or 6 or 7 feet tall.
Yeah, something like that.
Yeah. And the plant material is, if I correctly recall, some of it has to be planted at a height of 6 feet.
I believe you're right.
And do I correctly understand that it is believed the motorist on 291 will have only a limited view of the panels on the ridge immediately after that opaque fence goes up.
That will limit some of the views. That's correct.
Including those on the ridge.
I believe I just told you that I don't think I specifically looked at the views of the ridge.
You don't know the elevation of the ridge either.
Well, I don't have it in front of me, but I could certainly find it soon enough.
Ask this, Dr. Hall. In your assessment, in your broad-ranging assessment, which doesn't only include the economic and socioeconomic impacts, apparently, would it make sense to suggest that to reduce those impacts, that some landscaping be put in place on the ridge?
Well, there wouldn't be any views of a ridge at that point, would there?
Rather look at a ridge with some landscaping or a ridge with a bunch of solar panels going up and down its side. That was more rhetorical. You don't have to answer that. Thank you very much. That's all I have.
Thank you, Dr. Hall. You're excused at this time.
Thank you.
And just to confirm,
Your Honor?
PPRP, yes? You muted yourself again.
I have a couple of redirect for Dr. Hall, some points of clarification if possible, based on what Mr. Drummond just asked him.
Sure, I was trying to let him go, but if you want to redirect
And I
briefly, that's fine.
appreciate that, Your Honor. I really do. I'm going to be very brief.
You muted yourself again.
I apologize. I'm not very good at this virtual hearing thing. I apologize. Dr. Hall, do you have the project assessment report PPRP provided as a pre-filed document in this docket?
I do.
Okay, could you turn to page 33 through 34? Let me know when you're there.
I'm there.
Okay, I think Mr. Drummond was asking you some questions about the elevation. Do you see it somewhere on these two pages?
At the beginning of the visual impacts section, I did state that terrain elevations within the project site increased from around 10 meters to 32 meters near the northern boundary of one of the two parcels. The arrays themselves are located within an elevation range of 10 to 21 meters.
And also, thank you, Dr. Hall. Also, Mr. Drummond asked you some questions about the landscape buffering in this case. Could you tell me what landscape buffering were you referring to in your reply testimony dated March of 2020? Was it that included in the application, or was it that including in the settlement, proposed settlement?
I think that, well, I'm not sure what was included in the settlement. The applicant's proposed buffer was a linear buffer along 291. Based on my visual impact analysis, I made recommendations for buffering along the east side of the project and the west. And I'm not sure. I do believe that the applicant agreed to that. I don't know whether that is in my reply testimony or not.
Do you remember at that time what the applicant had agreed to, how wide the buffer was?
When I did my reply analysis?
Yes, yes.
I think that it was before the applicant agreed to a wider buffer.
And do you remember the setback at that time that you were viewing, you were considering in your analysis?
Well, setbacks varied from 90 feet from Morgnec Road to 150 feet where the project abutted wooded parcels owned by neighboring property owners.
All right, thank you, Dr. Hall. That's all I have.
Thank you, Dr. Hall. You are excused.
Thank
And
you.
just to clarify, that PPRP exhibits
Gosh,
15
okay.
and 16 were entered into the record.
Yes. I hate this.
Yes, Ms. McLemore, you are not muted right now.
Oh, I apologize. I can't operate this computer. I apologize for my inabilities. Yes, Your Honor, at this time, I would like to enter both PPRP Exhibit 15 and PPRP Exhibit 16 into the record with the exclusion of the lines that you did strike.
Yes, they are admitted. So I think now is a great time to take a lunch recess. We will be in recess until 2 p.m.
I can't find it. Where is it?
You're not muted.
I'm sorry. I can't. I can't mute it. Just get over there. I can't do this.
This is Kenny. I just want to do a sound check. I'm not signed on twice, correct?
Sounds good to me, Kenny.
Thank you.
Although I heard an echo there.
Guys, this is Sandra. I'd like to do a sound check too. Can everybody hear me? David, can you hear me?
Yep, you sound good.
And it's not too low?
Do I still have that echo?
No, that took care of it.
Thank you.
Oh, no, it's back. I'm sorry. It's a late echo.
I think I'm on twice. I may have to sign out.
Okay.
I'm not sure why I'm on twice, but that's what it looks like. Is there an echo now?
Check, sound check.
Thank you.
No, no echo.
Thank you.
Your Honor, am I loud enough for you to hear me as well?
I can hear you loud and clear.
Thank
But I
you.
can also hear myself.
Sandra, you have an echo on yours still.
Ms. McLemore, do you need another minute?
Your Honor, I'm just gonna look on with Mr. Sedzinski and work on this computer. Can you hear me okay here without an echo?
I think that will be fine
Okay,
until he's a witness.
absolutely. Yeah, we're getting another computer as well.
Okay. All right, Mr. Court Reporter, are you ready to go back on the record?
You're on the record, Your Honor.
Thank you. We're back on the record in case number 9499. Mr. Bugelmans, your witness.
Thank you, Your Honor. The applicant will call as this next witness, Eugene Ryang.
Hello, can you hear me?
Yes.
Great.
Can you raise your right hand, please? Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes.
Mr. Bugelmans?
Thank you, Your Honor. Can you please state your
Mr.
name?
Bugelmans, I'm sorry, the attestation first.
Oh, I'm sorry, Your Honor. I need to get used to that. That written down somewhere. I hereby attest that the witness is alone in a separate room and not in communication with any other individual.
Thank you.
Thank
Proceed.
you, Your Honor. Can you please state your name and provide your business address?
Yes, Eugene Ryang, with Water Street Studio. The business address is 418 East Main Street in Charlottesville, Virginia, 22902.
And what is your company and title?
Water Street Studio.
And what's your title?
I'm principal.
Thank you. They have before you a document entitled Direct Testimony of Eugene Ryong, PLA, dated August 2nd, 2019, consisting of 35 pages, inclusive of attachments.
Yes.
Thank you. Your Honor, I would like to request this document be marked as Applicant Exhibit 19.
So marked.
Thank you, Your Honor. Mr. Ryong, do you also have before you a document entitled Rebuttal Testimony of Eugene Ryong, PLA, dated March 20th, 2020, consisting of 28 pages, inclusive of attachments?
Yes.
Your Honor, I would like to request this document be marked as Applicant Exhibit 20.
So marked.
Thank you, Your Honor. Mr. Ryong, were these two documents prepared by you or under your supervision and control?
Yes.
If I were to ask you the same questions today, would your answers be the same?
Yes. However, I will say that the settlement does seem to have some adjustments or some new requirements from our original design proposal.
With this clarification, would your answers be the same if I asked you these questions today?
Yes.
Thank you, Mr. Ryong. With that, Your Honor, I would request, I'm sorry. With this clarification, in addition, is your testimony true and correct to the best of your ability?
Yes.
Thank you. With that, Your Honor, I'd request to move applicant exhibits 19 and 20 into evidence.
Any objections? Hearing none, applicant exhibits 19 and 20 are entered into the record.
Thank you, Your Honor. And with that, the witness is now available for cross-examination.
Mr. Drummond, do you have any questions for this witness?
Thank you, Your Honor. Mr. Yang, excuse me. My name is Chris Drummond. I represent Kent Conservation and Preservation Alliance, an intervener in this case. Are you able to hear me okay?
Yes, I am. Hello.
Yang, in your direct testimony, you attach the plan that was originally proposed for this application, and what you refer to as a series of hedgerow landscape typology photographs or simulated photographs. Are you familiar with what I'm referring to?
Yes.
All right. Could you direct my attention to any of the hedgerow landscape typology photographs that emanate from Kent County, Maryland?
I don't fully understand that question.
Clearer I can make it.
Are you asking me to show you photographs of Kent County hedgerows?
Asking you if the hedgerow landscape typology photographs attached to your landscape plan show hedgerows in Kent County, Maryland.
Let me look for these images. Those are precedent images of hedgerow landscape typologies. I'm not sure any of these are specific to Kent County, Maryland.
All right. What was the word you said at the beginning of your answer? These are
precedent images.
Precedent images.
Examples of.
So I'm asking you, so your answer is that to your knowledge, none of these represent a hedgerow in Kent County, Maryland.
Well, I will say that there's probably thousands of hedgerows in Kent County, Maryland, because it's just part of the agrarian typology. Because anytime there's an agrarian landscape, people clear land, they'll put their rocks in the hedgerows, and then hedgerows are typically natural occurring planting zones, planting areas. Some are buffered in time, but or planted in time, but they're usually just naturally occurring and left alone, and that's why they're called hedgerows.
That dissertation. My question is whether none of these hedgerows are located in Kent County, Maryland.
The pictures that we have represented are examples of hedgerows that are not, that I know of, and this is with my team, hedgerows in Kent County, Maryland.
Okay. Do any of the hedgerow landscape typology photographs show a hedgerow that is approximately a mile long?
In the precedent images, you're asking, Mr. Drummond?
Yes.
I couldn't tell you if they were a mile long or not from those images.
Well, do you know enough about hedgerows in Kent County, Maryland to direct our attention to one that is approximately a mile long?
No, but if I took a site visit with you, I'm sure I could show you a few.
I'm asking you that, Mr. Riang. I'm asking you to, you described the hedgerow that you proposed as consistent with hedgerows in the Kent County, Maryland area. And I'm asking you to tell us what hedgerow.
Mr. Drummond,
Yes, ma'am.
in the morning session, I think it was illustrated that it's very helpful and fair to the witness if you direct the person to where in their testimony you're referring. That avoids any misstatement, whether intentional or innocent, of what their testimony actually is. So if you could try to do that, that's a practice fairly common in the commission, to direct the witness to where in their testimony you're referring so that we can all be on the same page and nothing gets misstated. Thank you.
Mr. Drummond, if you look at a Google map of Chesterton County,
There's no question there.
you'll see quite a number of hedgerows.
Okay, Mr. Riang, I apologize, Judge Lawrence. I'm not used to being required to cite exactly where someone in direct testimony has said something when you're cross-examining them, but I'll do my best. Page 2, line 22. And 23. Do you have that before you, Mr. Yang?
I do.
All right. So you indicated that the design intent of the buffer is to plan and design a hedgerow similar to hedgerow plantings in the surrounding agrarian landscape. And by surrounding agrarian landscape, I assume you meant in the Kent County area, perhaps even more specifically in the general area of this property.
Yes.
Okay. And so now I'm asking you, where do you find a hedgerow in Kent County, Maryland, that is on the order of 1 mile long?
I probably couldn't give you that example right now.
Okay.
I mean, but if I went out on site with you, or if you look at a Google map, you'll probably see some fairly significantly extensive hedgerows. It's just part of the agrarian landscape. It's throughout the entire United States of America, throughout the entire world. It's just hedgerow. That's what you do when you have agricultural fields. You move the rocks off the field, and hedgerows are created as windbreaks or erosion and sediment control. It's just
Judge
part
Lawrence,
of
could you ask him to, let me ask a question?
Well, I think he was finishing his answer of your last question, but you can go on to your next question.
And the next question is, consequently, Mr. Riang, you are relying upon what you believe to be the sort of generic agrarian landscape.
Are you asking me a question?
In your testimony that this hedgerow is typical for a hedgerow in Kent County?
Actually, and I'm sorry if I'm elaborating a little bit, but we were asked to provide a planted buffer for the project. And as landscape architects, you know, and particularly our particular firm, we don't like to just plant landscape buffers for projects. We like to think about it from a more global perspective. So, and without going into too much detail, we're thinking about it largely as an ecological corridor that within the framework of a hedgerow, which is part of all the ecological corridors, when you have a fragmented landscape through development, and development can include subdivision development or farming, for example, or agriculture, you want to create ecological corridors and patches. And one of the most viable ecological corridors in our lost landscapes are hedgerows. So we're ostensibly creating an ecological corridor and a hedgerow. We're basically jump-starting a hedgerow on the edge of Morgnec Road that provide a landscape buffer for the project.
How wide is the buffer that you designed, Mr. Riang?
Originally, I think it was 30 feet, but the settlement, I think.
I'm talking about originally.
Originally, I believe it was 30, and I think it went up to 60 feet, which actually substantially enhances the buffer.
30 feet is an ecological 30 feet wide by 1 mile long is an ecological corridor in your estimation, Mr. Riang?
Yes, it can be if the opposite is nothing.
Opposite is the view of a decades-long agricultural use of property. Is that nothing, sir?
No, I'm saying as an ecological corridor, by definition, fragmentation occurs through all kinds of development, and agriculture is actually one of the most harmful fragmentation instruments upon our land. So if you can create ecological corridors and patches in a large mosaic of the landscape, then that's a very good thing that we're doing. I mean, even with farmland, if you can create a hedgerow, it's a good thing.
Mr. Riang, is a 6 foot or 7 foot tall chain link fence with opaque screening part of an ecological corridor in a rural landscape?
There are fences and infrastructure and landscape. I don't know, I would say from a north-south perspective, you wouldn't have that biological flow because you have a fence. So that's not particularly useful. But from an east-west perspective, and it's not exactly east-west, but from an east-west perspective, along the road, along the corridor, immediately adjacent to the road, then it is an effective ecological corridor, yes.
Take it from your point of view, that actually improves the experience of the motorist driving along 291, that is to replace the view of an agricultural field with a chain link fence with opaque screening?
No, but with a planted buffer, yes.
Does your plan propose to irrigate the plants that are to be installed?
According to the settlement, we hadn't got into we just
I'm
provided.
talking about the settlement, Mr. Riang. I'm not talking about that yet.
No, we just provided a concept plan. We had not moved into design development or construction documentation. So that's up to, I think that the settlement says it requires irrigation, but We don't have a
About that,
contract.
sir.
We don't have a contract for that work yet.
What would you recommend with respect to irrigation?
Well, typically we would plant native plantings. So we want to water for 3 seasons until they establish. It's not an ornamental garden. So with the plantings that we recommend, they should establish themselves after 3 seasons. So probably
Are
water
you-
trucks, I would imagine.
Water trucks.
Yeah,
That's
water
your
trucks.
proposal?
Probably
Brian,
trucks.
have you undertaken to look at the mortality of landscaping buffers planted around other solar projects on the eastern shore of Maryland? Don't look at Mr. Chase and Mr. Bugelmans. Mr. Riang, have you undertaken to look at the mortality of material and other landscape buffers on solar facilities on the eastern shore of Maryland?
No, I have not.
You know that almost all of them, no, not almost, every one has resulted in mortality in excess of 70%.
I'm sorry, Your Honor. I'm gonna have to object to this. This is outside the scope of Mr. Ryong's testimony. He testifies.
Wait, hold. I'm going to sustain the objection because he just said he had no familiarity and then was asked a follow-up question. So it's not a proper question. So your objection is sustained.
I don't mind answering it. I mean, because really, irrigation
No,
is like.
Mr. Ryong.
I shouldn't answer. Okay.
No. Wait till the next question, please.
Okay.
And your the photo simulations that you provided, sir, which again, Your Honor, are attached to, I don't know, they're not, actually they do have page numbers. They're attached to your testimony. They're called typical road/buffer sections with various years. You have those, Mr. Yang?
I'm looking for them.
Actually,
Yes, I do. Yes.
elevations, and then there's some photographs.
Yeah, perspective. Yes.
I don't see in any of these documents, sir, reference to or the elevation of the ridge on the property that is in an east-west direction north of 291. Is that correct?
Actually, we worked with the the architects involved in the project, and they 3D modeled the project. So they had 3D modeled the terrain using existing conditions, and then they put the panels, the infrastructure, and they used according to the cut sheets, including the transformers and the inverters, and everything was put in based on the model. So the perspectives that we took, the snapshots that we took were from the drive along the road and across the property, looking at the property. So I believe that elevation that you're talking about, that rise is, I think it's about a third of a mile into the property, about 1,400 plus feet into the property, and rises about 30 feet. So it's not like a ridge per se, but it's a rise certainly. But I think that from my understanding of the architects, all of that was accounted for in the 3D TIN modeling, triangulation modeling. So all those images are accurate as per the model.
What architecture are you referring to?
The architecture firm with whom we worked was Design Develop out of Charlottesville, Virginia. They do 3D modeling.
You look at your typical road/buffer section.
Yes.
chart. I don't know what you'd call that. It's not a chart, but you get my point.
Yeah, graphic. Yes.
Graphic. Okay, thank you. Is this also premised upon the quote unquote 3D modeling of the architect?
No, this was just based on a section, a section. Imagine you cut a section through the edge condition along on Route 291 and to the solar
that
array field.
We may conclude that the elevation of Route 291 and the elevation of the property before we get to the ridge are about the same.
I think there's a topographic difference, but this was just an abstraction of what that section would look like. So I believe, my understanding, if I can recall, there is a rise from Route 291 all the way back, which is what, 3,000 plus feet north south roughly. I mean, it varies, but there's going to be a consistent rise all the way to the backwoods with a small with that elevation in between that you're talking, that you're calling the ridge, and that ridge right in about third of a mile in.
Therefore, if I correctly understand your testimony now, the typical road buffer section graphics do not accurately reflect a cross section of the Clark Farm property because it isn't flat.
Well, it's not exactly flat, yes, but it's a pretty close approximation of what we determined to be the section from the road.
Told us that the property rises in elevation from the road to the ridge. You just told us that.
Right, but Mr. Drummond, this thing is like, we're in the coastal plain here. By rise, it is barely perceptible through experiential or visual. I mean, it is a slow rise. This is not the Piedmont or the mountain landscape. This is just the coastal plain. Everything's pretty flat.
Nevertheless,
relatively speaking.
Nevertheless, this graphic does not accurately reflect what's on the ground.
It's not exact topo one-to-one, exactly, but it is a pretty close approximation to what it is, and as do the perspectives and the.
Why did you not give us another graphic that showed the elevation, the top elevation of what I'm calling the ridge?
The model images that you see in the exhibit
on these graphics, sir.
On these graphics, on these exhibits were 3D modeled on existing conditions with the cut sheets of that infrastructure laid on top of it. So the views that you see, in fact, actually, if you look at the photographs from.
I'm not talking about the photographs, Mr. Yang. I'm talking about your graphics.
I am talking about the graphics. I'm sorry. The graphics are actually, there's a little rise immediately above the road, and then it's relatively flat all the way across. So if anything, you have it's actually a little bit higher. The ground is higher from the road itself.
You're not listening to my question, Mr. Yang. My question is, why did you not provide the applicant and the Public Service Commission and the rest of us a graphic that shows that what I'm calling the ridge?
The ridge is inward of the site. Our job was to provide a planted buffer, not to look at the ridge, Mr. Drummond.
Oh. So, in other words, you were not called upon to determine whether your landscape buffer would shield the view of these panels on the ridge.
I'll repeat that we received a 3D model that was based on existing conditions that included the ridge that you talk about. Not a ridge per se, but a rise in the land in the middle of the landscape with the infrastructure laid on top of it. And so our job was to provide a planted buffer, which we took a larger global perspective on, ecological corridor, and took views. They took the snapshot views from across what it would be like to be driving along Route 291 and views across on the adjacent property to see if you would see the infrastructure, the solar panels. And so that's what is indicated in this exhibit with all these images. Yes.
Yang, you have not been called upon, I take it, to work with a landscape plan consistent with the so-called settlement agreement?
No, that came after our initial proposal, and it seems to have substantially enhanced it, like a lot,
Okay.
by a lot.
So you don't know how many solar panels will have to be removed to comply with the so-called settlement agreement?
I'm not aware of that. No.
Mr. Yang, can you direct our attention to any lengthy hedgerows that exist along either state roads or collector roads in Kent County?
I can't direct you to anything specific, Mr. Drummond, but I'd be glad to meet you on site and show you hedgerows along the
I think it might have been,
drives.
don't you think it might have been important, Mr. Yang, to determine whether the landscaping that was proposed and is now in part of the so-called settlement agreement bears any relation to hedgerows along major roads in Kent County?
Can you repeat that again? I feel like I'm answering the same question over and over again, but there's hedgerows all over the place.
I'm asking you specifically whether there are hedgerows that go along the right-of-way.
I'm going to have to piggyback off of that, Your Honor. Mr. Drummond's asked this question 5 or 10 times. He's asked the same question over and over again.
Not with respect to roadways. That is, whether the roads in Kent County have a tendency to have this tunnel of hedgerows down them, which is what is proposed.
I wouldn't say they're a tunnel. It's just part of that's the road edge condition next to farm.
Mr. Rang, I know you're trying to be helpful. Mr. Drummond, I think you've mischaracterized the proposal in this case, and I would caution you to try to not do that. Okay, I would agree with Mr.
Explain to me
Dugan.
how I've mischaracterized it, Judge Lawrence.
Tunnel.
This is cross-examination.
No, you are telling him what something is as if it's a fact, and it's not.
I'm saying this is cross-examination.
And you are mischaracterizing what you are stating to the witness as fact. So I would urge you.
I think you get to do that as part of cross-examination.
No,
but
sir.
All right,
No, sir. That's not what cross-examination is. So I agree.
Not in this context, it's not. But I don't have any other questions. I might say, I don't want to editorialize too much, but
I'd urge you not to.
Nothing further.
Thank you. Mr. Yeager, are you on the line?
Yes.
Do you have any questions for this witness?
Mr. Riang, I take it that you have done a site visit to this property.
Yes.
And what is roughly the road frontage on Route 291?
It's about maybe almost 4,700, maybe 5,000 linear feet. Maybe it's a mile almost.
About a mile. So
Yeah.
substantial, you would agree.
Yes.
And having a hedgerow lasting a mile, that's pretty substantial, isn't it? It's not something you typically see.
You do see them throughout the United States, yes. throughout.
Well, let's say Kent County. Let's talk about the Kent County landscape and Kent County farms. You would agree with me that a mile hedgerow is not something you typically see in Kent County.
That I don't. I mean, I'm sorry. Because I haven't been to Kent County that much. I would not. I can't say one way or the other.
So you didn't go and do any
Along the roads. Along the
You
roads.
didn't do any type of inspection around the county to try to get a feel of hedgerows and landscaping around the county. That's what you're saying. You don't know.
Well, we would do these. We would look at our Google Maps and study from aerial maps.
Okay.
Yes.
So based on that, you would agree with me then that we don't typically have mile-long hedgerows in front of farms in Kent County then?
You have them on property boundaries along farms, but I couldn't say one way or the other on the roads.
On a road frontage.
On road frontage.
I'm not talking about where it's not a vista or a gateway to town. I'm not, that's what I'm talking about. I mean,
I have to object to this. The witness has already answered this question.
All right, we'll just accept his answer. He doesn't know, and he didn't go out there and inspect.
I was charged we were charged to provide a planted buffer. And so what I'm saying is I think we're confusing hedgerow with planted buffer. I mean, it's the same thing, essentially. It's just two semantics.
Well, you called it that. You use those terms interchangeably.
Right, because we're keen on, like, if you're a landscape architect or an environmental planner and you're not thinking about restoration, ecology, and environment, then you're not doing your job these days. So we can assume,
will you agree with me that when you were saying a hedgerow and buffer, you were using those terms interchangeably? Would you agree with me on that?
Yeah, it's a planted buffer, but we could just stick a bunch of plants in there in a row, but we want to be very thoughtful about how we're planting this thing, where we have canopy trees, subcanopy, small flowering shrubs, and native plants, so that we can create a viable ecological corridor. I mean, we could call the ecological corridor, we could call it a hedgerow, we could call it a planted buffer.
We could call the tunnel. It could have a tunnel effect, could it not?
Well, it's a tunnel effect as if you have like trees growing over each other on two sides. That's the definition of a tunnel. This is creating a planted buffer, which you want. I presume we would want a planted buffer, whether it's any kind of development.
Now, I take it that you have been to the property, right? You've been on the site, and you've seen that ridge. It's pretty obvious, isn't it? You can easily see that ridge driving down the road.
Not with a planted buffer, you cannot see it. But
I'm not talking
now. I mean, you see a rise in the landscape.
Sir, I just want you to answer the question, sir. I want you to answer the questions as they are asked, okay?
Mr. Yeager, he was answering your question if you would let him finish.
He was trying to throw a hypothetical in there. What I'm asking him is, as you drive.
I can't understand when people talk over one another, and this is what's happening. Please slow down.
Okay, how it works is, sir, I'm asking you the question. I would like you to answer the question that you are asked, okay?
Okay.
All right. If you were to drive down Route 291 today, that ridge would be pretty obvious, wouldn't it?
I'm not sure, Mr. Mackey.
Excuse me. I'm Mr. Yeager. I should have introduced myself. I apologize.
Okay.
I'm next to Mr. Mackey. Mr. Mackey's the planning director. I'm the county attorney. So
Okay, sorry.
I'm sorry about that.
No, I'm sorry about that. I'm not sure that you'll be able to see it, Mr. Yeager. It's just I think you're going to be driving along and at 45, 60 miles an hour. I don't think you call it a ridge, but there's like a rise in the landscape in the middle of that farm. I just don't.
That extends a substantial distance. You can't miss it when you drive by there.
Can you please ask a question, Mr. Yeager?
So you would agree with me that if these panels are on a ridge that's a good 30 feet in height on top of the gradual slope that you get between the roadway and where the ridge starts, that you're going to need a substantial buffer to shield that from eyesight if you're driving down the road. Would you agree with me on that point?
At the buffer as provided, yes.
Okay. And when we look at your pictures, driving view, year one, from your testimony, Driving view, year 5. It is unlikely, is it not, that on year 1, those solar panels on that 30-foot ridge are going to be shielded with the buffer that you proposed.
I think maybe a better graphic would be adjacent property view year 1. And
Okay,
adjacent
sir,
property
I want you to
directly.
answer my question.
But according to those graphics, then I have to say you can't see them because it's the way the perspective is while you're driving on the road. You're lower, your whole perspective is so flat on when you're looking at the rise that you're not going to see that, especially with that fence, right? With a fence with a screen on it. So it's likely you won't see it.
Where you're driving, this ridge lasts a good mile.
Is that a question?
Well, I was starting a question. If I'm allowed to finish, I can have a question, I guess.
There was a long pause after your statement. I wasn't
I'm
sure.
sorry, Your Honor. I'm very hoarse today. I've been fighting off something. And I'm losing my voice, so I apologize for that. But sir, it's fair to say that when you have a ridge that is a good 30 feet up, and it lasts, let's say, a mile, that ridge is visible from the road that parallels it. You're not disputing that, are you?
No, Mr. Yeager, I'm just going on based on the modeling provided by Design Develop that was modeled on the 3D model based on the existing conditions with the infrastructure on top of that, including the ridge that you're talking about.
Right.
You can't see it. You cannot see it from the road with that fence there. You barely may get a glimpse. I don't even know if you get a glimpse of it, but you can't see it because that fence.
Right. Year 1, year 5, year 25. When can you not
year
see
1. I'm just going based on the modeling and the image that year 1 you probably won't see it.
Your testimony is with the plantings on this graphic, year 1, that you can't see the solar panels that are sitting up on a 30-foot ridge that runs for a mile? Is that your testimony, sir?
No, I'm saying, Mr. Yeager, it depends on the distance. Like that ridge is not like is it how close is it to the road? The ridge is probably a third of a mile back off of the road. And that ridge that we're calling a ridge is what, maybe 30 feet, maybe 30 feet. So, and it's a flat slope that goes up 30 feet. It's not like a vertical slope. So I can't say one way or the other, but based on the modeling that's done and based on existing condition and the cut sheets and everything that's been laid, my opinion as based on that says that we probably won't be able to see it.
Probably. So
I'm just going on what I know.
And you never measured the ridge, I take it. You don't have
we didn't get
topographic data. You didn't measure the height of that ridge, I take it.
The architecture firm with whom we worked was working it based on existing conditions topo. Yes. We took
Do you have a measurement
triangulation model. Pardon me?
Do you have a measurement? We're talking 30 feet. Do you have a measurement? Can you confirm that number is accurate, that it is 30 feet? Or could it be 40 feet or 28 feet? You have the number of what the ridge is.
I thought you said 30 feet, but I think it is about 30 feet.
All right. Thank you, sir. I have no further questions.
Mr. Hicks, do you have any questions for this witness?
Briefly, Your Honor, thank you. Good afternoon, Mr. Ray. My name is Jesse Hicks. I represent the town of Chestertown. How are you?
Hi, Mr. Hicks. How are you?
I'm good. I just want to be clear. The plan that you submitted that was just submitted as evidence, that was a concept plan, correct?
Yes.
Okay, so that wasn't based on any type of settlement.
Let me slow down. You just talk too fast.
I've been told that before. Thank you. I apologize. Regain my train of thought. The concept plan that wasn't based on any of the settlement agreements, correct?
Yes, correct.
Okay. And since this concept plan has been completed, there's been two settlement agreements that would change how you structured this concept plan?
Yes, I would presume that I mean, it's changed it. The setbacks are different, buffer widths are
And-
different. Yeah.
I think you said before the new settlement agreement was substantially different.
Well, I said substantially, seems like it enhanced it. It made it hopefully better in terms of, I'm just thinking about from my perspective as a landscape, from an ecological perspective, a 60-foot ecological corridor is better than a 30-foot ecological corridor.
But it's a substantial difference from what you anticipated.
It's about twice as wide, yes.
And just briefly, you're aware the solar panels are intended to be about 8 feet tall at their highest?
That's my understanding. 6 to 8
Okay.
feet tall was my understanding. Yes.
And your fence is to be 6 feet tall?
I believe that's it.
And then a foot and a half of barbed wire on top of that.
The barbed wire is new to me. But I guess you don't want people crawling over that fence.
Pork indulgence. I would just direct your attention to page 5 of your direct testimony, line 3. What is the proposed height of the perimeter fence? Your answer, the proposed height is 6 feet tall with a 1 to 1.5 foot barbed wire topper.
Yeah, I guess that's correct. I don't remember putting that in there, but that was also 3 years ago.
Okay.
Yeah.
Fair.
Sorry
That's
about
fair.
that.
And then additionally, within that chain link fence, there would be a green opaque element, as you refer to it.
Yeah, screen of some sort. That was just, I think that was what we recommended. If the concern was that you could see through in the first year, just directly through.
Okay. I believe you referred to them as precedent images.
Yes.
The ones I'll be referring to are on page 21 of your exhibit, of your report. Good.
Yes.
Quickly, none of those show any type of chain link fence within those precedent images.
I would probably agree with that.
Okay, so it would be safe to say that none of them show a chain link fence with any type of opaque screen in it.
Yes.
Okay. Worth indulgence. I think you answered all the other questions I had. Thank you, Mr. Rang.
Thanks, Mr. Hicks.
Mr. Bugelmans, any redirect?
I have no questions, Your Honor.
Thank you, Mr. Ryan. You
Your
will be
Honor.
excused.
Thank you.
Mr. Bugelmans, do you want to proceed to your next witness?
Yes, Your Honor. Next, I will call Mr. Fletcher Mangum, PhD.
Sir.
Mr. Mangum, can you please raise your right hand? Do you swear or affirm under penalties of perjury the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Attestation, Mr. Bugelmans.
Thank you, Your Honor. I hereby attest that the witness is alone in a separate room and not in communication with any other individual.
Thank you. Please proceed.
Thank you, Your Honor. Hello, Mr. Mangum. Can you please state your name and provide your business address?
My full name is Alan Fletcher Mangum. Last name is spelled M-A-N-G-U-M. Our business address is 4201 Dominion Boulevard, Glen Allen, Virginia, 23060.
What is your company and title?
Our legal name is Mangum Economic Consulting. We do business as Mangum Economics.
Thank you. Do you have before you a document entitled Direct Testimony of A. Fletcher Mangum, PhD, dated August 2nd, 2019, consisting of 54 pages inclusive of attachments?
I do.
Your Honor, I'd like to request this document be marked for identification as applicant exhibit 21.
So marked.
Thank you, Your Honor. Mr. Mangum, was this document prepared by you or under your supervision and control?
Yes, it was.
If I were to ask you the same questions today, would your answers be the same?
Not entirely. This report was provided 2 years ago, and some of the conditions have changed. One of the first and foremost is that the utility tax rate for Kent County at the time this report was prepared was $2.55. It is now $2.53. If we reran the model based on that new tax rate, it would lower our fiscal impact assessment by approximately 1%. As stated in the report, we did not include any additional revenue that the locality would receive, that Kent County would receive as a result of the reassessment of the real property, the dirt itself. Those assessments or future assessments were not available at that time. In the 60 or so solar projects that we have done across 8 states since then, where those assessments are available, what we find is that revenue stream for locality typically accounts for about 1/3 of the overall revenue pie. If that were the case here, then the fiscal impact assessments that we provided in 2019 would understate that fiscal impact by about 50%. The last thing that I would change is that our understanding of how the Maryland Department of Assessments and Taxation assesses the equipment itself has evolved, or have we achieved a clear understanding. When this report was compiled, what we used as that initial assessment were the price of the panels themselves, what Urban Grid would pay for the panels.
Your Honor, I'm going to
themselves.
object to this. It's my understanding, which you have been confirming today, is that we rely upon, the Public Service Commission relies upon written testimony, which is submitted within certain deadlines, and we're kind of stuck with what we have in our written testimony. And you have admonished me several times today when I have been asking questions to refer to the written testimony. That seems to be the backbone of how these matters proceed. And here we have the applicant asking a witness to supplement his testimony orally, which, as far as I can tell, directly contradicts the directions that we all have received prior to today.
Mr. Magnum, is it safe to say that if you did your analysis now, you would need to update things from your testimony that was filed?
That is correct, Your Honor.
Okay. Mr. Bugemans, I think we can proceed.
With that, is he able to finish his response, Your Honor? Or...
Yes, Mr. Drummond, the point I think that Mr. Bugemans was trying to make was that the questions he goes through to make sure the testimony can be admitted provide that the answers are true and correct. And I think that what was trying to be done was clarify that they were accurate at the time and perhaps would have changed now. And I think we've established that, so we can move on. Am I right, Mr. Bugemans?
That's correct, Your Honor.
Okay. Go ahead then.
Mr. Mangum, if you could please finish your update.
Oh, actually, I think what I've decided is we know that he would update it to be accurate today. I don't think he needs to do it. I appreciate that he would have to.
Okay. Subject to your identified updates, would your answers be the same today if I were to ask you these questions today?
Subject to the updated information, yes.
Okay. Is your testimony true and correct to the best of your ability, subject to these updates?
Yes.
Thank you, Mr. Mangum. With that, Your Honor, I request to move applicant exhibit 21 into evidence.
Any objections? Hearing no objections, applicant exhibit 21 will be entered into the record.
Thank you.
Go ahead, sorry.
The witness is now available for cross-examination, Your Honor. Thank you.
Mr. Drummond, do you have any questions for this witness?
I have a few. Thank you. Mr. Mangum. My name's Chris Drummond. I represent Kent Conservation and Preservation Alliance. Mr. Magnum, I recall you and your testimony from a prior matter before the Public Service Commission where the applicant was known as Mills Branch Solar. Do you recall that case?
I do.
And is it fair for me to characterize your testimony in this case as, by and large, a repeat of your testimony in the Mills Branch Solar case?
That testimony was in 2016, if I recall correctly. I really can't tell you if they are the same.
You told the Public Service Commission then that the Mills Branch Solar project would produce a one-time pulse of economic activity in Kent County, Maryland, and would produce on the order of 250 jobs. Do you remember that?
Again, Mr. Drummond, I do not have that report in front of me. That analysis was 5 years ago. I really can't comment on that.
I guess my question is, do you essentially change the names and produce the same testimony?
Not at all. The inputs from the two applicants would have been different. I don't recall, again, the specifics of the study that you're referencing from 6 years ago. I don't know if the megawatts were the same. I really am not in a position to comment on that.
How many of the 258 temporary jobs that will produce this one-time pulse of economic activity will go to residents of Kent County?
The way that we accomplish that is that out of the entire budget on construction, which if I recall correctly was about $43 million, we look at just those aspects of the project that are likely to be served by local contractors or subcontractors. Generally, that is just...
How many of the 258 temporary jobs that will produce a one-time pulse of economic activity in Kent County?
I have to object to this, Your Honor. He was answering the question. He was interrupted.
He was interrupted, and then I think Mr. Drummond is now repeating the question. So maybe he will be able to answer after Mr. Drummond repeats the question. Are you repeating the question, Mr. Drummond? Mr. Drummond?
I repeated it. Oh, you want me to say it again? How many of the 258 temporary jobs that will produce a one-time pulse of economic activity in Kent County will be provided to Kent County residents?
It's impossible to ascertain that with any specificity. However, if I might comment, the in-plan model looks at in-commute and out-commute rates for that sector within the county and uses that information to provide as accurate an estimate as possible. But of course, it's impossible to know with any certainty precisely how many of those jobs would go to Kent County residents. But according to the estimates provided in the model, we would assume that most, if not all, would.
These would be jobs that would be excavating holes and pouring concrete in and then putting up the stanchions that hold the panels, and then the panels themselves are being installed. And you're saying that would be Kent County, primarily Kent County residents.
If I'd been able to finish my first comment on that, what I was telling you was that when we do this, we only take into account those portions of that overall $43 million construction budget that would be used for site preparation or general construction. Quite typically, the crews that are used for the installation itself come from outside of the county. Those are excluded from this analysis.
Calculate how much Kent County you would expect Kent County to receive in piggyback income tax for those Kent County residents that are employed to construct this project?
That estimate is provided in the report. If I recall correctly, it is not divided by category, or it is not divided by category, and it is also not specific to Kent County. In the in-plan model, what we're able to provide is a fiscal impact assessment for that project that would be state and local revenue. That estimate, as reported in the report, was $712,000, which would be inclusive of the income tax that you are asking about.
How much of the $712,000 would be collected by Kent County from piggyback tax?
As I said, we do not have that information at that level of specificity. What we do have from the in-plan model is that total state and local tax revenue from that project would be $712,000 approximately.
We're unable to specify the benefits to be received by the county in which this project is proposed.
It would be part of that $712,000. I'm not able to answer your question at the level of specificity that you have requested.
It could be $70 or it could be $70,000.
I think that those estimates are both extreme.
You estimate that this economic input will total 20, the impact, I should say, will be $22.3 million. And that's on page 3 at line 16 and 17. How much of this first of all, what is the economic input?
That is not an input number, Mr. Drummond, it's an output number. And what that is that, again, out of that $43 million.
Wait a minute, Mr. Magnum, please. I've been admonished to refer to testimony, so you please refer to yours.
Yes, and Mr. Drummond, he was correcting your misstatement. You said input, and his testimony says output.
My fault. I apologize. What's the $22.3 million in economic output?
$22.3 million in economic output. The total construction budget for the project was $43 million. That is the overall economic activity that would be generated as a result of those functions that we discussed, which would be site preparation and general construction. And that is the total economic impact, which would include not only that direct portion, but also the induced, which would be those purchases, household purchases from employees of that construction project, and the indirect, which would be business to businesses purchases as a result of that direct impact. I do not have the direct impact number in front of me. So in brief, in answer to your question, that is the total amount of economic activity that would be generated by that project, including both the direct impact, the indirect, and the induced impact.
Economic output will stay in Kent County.
That is correct.
So how much of it will stay in Kent County?
The $23 million. Again, what the model does is look at the expenditure vector for those construction industries in terms of what their purchases are with respect to other industries. It overlays that on the economy of Kent County to identify which of those industries are in Kent County and what their economic footprint is to ascertain what part of that $43 million in total construction budget would end up, those dollars would remain in Kent County. So by the estimate of the model, that is that $23 million.
Identify for us the lumber yards, the concrete mixing plants, the and similar materials and labor facilities and employers in Kent County that are going to receive this $22 million in economic output?
By name?
Yes.
Or no, I cannot. What it is looking at is Bureau of Economic Analysis data on what the profile of those industries are within Kent County. And it's overlaying the expenditures from that construction site on that economic activity or economic profile of the county to identify on an industry specific area across 1,044 industries, what proportion of those dollars are likely to be spent with industries that exist within Kent County.
based upon the assumption that these industries exist in the county.
Based on Bureau of Economic Analysis data and Bureau of Labor Statistics data, yes, sir.
Hard to find a concrete plant in Kent County.
I don't
all
recall
right.
specifying that it was concrete. Again, it's over across 1,044 industries. I do not have a list in front of me of specifically which would be impacted within Kent County.
Sorry, Your Honor, I'm losing to have somebody else on.
It looks like Frank Depew is not on mute. Mr. Depew, if you could please put yourself on mute, we would appreciate that.
Could you repeat what you just said, because I did not get that?
Are you addressing that question to me, sir?
Yes, sir.
What I said was that in terms of the specific industries, the reference was to a concrete plant within Kent County. What the model does, what the in-plan model does, is allocate that economic output across 1,044 industries. And it looks to see which of those industries are within Kent County. And that is what would account for the 20-some odd million dollars in overall economic output. I do not have a list of those 1,044 industries in front of me, nor was it included in the report.
That's all the questions I have.
Mr. Yeager, do you have any questions for this witness?
Yeah, thank you, sir. Good afternoon. I'm Tom Yeager, the county attorney. I pop up here as William Mackey because Mr. Mackey is with me and I'm in his office. So what I gather is you cannot name any specific Kent County businesses from whom purchases would be made.
The estimate of the model is not at that level of granularity, nor can I name the names of the laborers that would be involved. What it does look at is the industries that exist within the county, what the expenditures for those industries would be, and then it uses that information to ascertain what the economic impact would be in terms of those dollars that are likely to remain within the county.
And you haven't done any independent verification to verify those statistics to see if those industries actually do exist in the county.
The in-plant model is one of the most commonly used in the United States. Again, it is based on Bureau of Economic Analysis and Bureau of Labor Statistics data. I have not confirmed the economic or the profiles that are within the in-plan model.
That's my question, is you didn't contact any of these businesses to confirm that they are currently operating and in the county.
Those data are based on information that was reported to the state of Maryland's Employment Commission, and then through that to the Bureau of Labor Statistics.
Hold on.
Mr. Magnum.
My question to you was, sir, you did not do any independent verification yourself of these businesses. You just relied on the Bureau of Labor Statistics. Is that correct?
As reported through the in-plan model, yes, sir.
Okay. And also, it's fair to say that you do not know, assuming these industries do exist in Kent County, you do not know if they have the capability and the capacity to supply the labor and materials needed for this plant, this construction project, do you?
Again, that information is part of the Bureau of Labor Statistics. If the economic footprint of that industry, or if the industry exists and its economic footprint is sufficient, then the in-plan model allocates a portion of that overall investment within that industry to that sector within the locality.
But you have no knowledge of your own as to whether or not, assuming these industries exist in Kent County, if any particular industry has the capacity to supply the materials and the labor needed for this construction project.
What the model does is that ascertains
Mr. Mangum?
Yes, ma'am.
That's a yes or no question. Did you understand the question?
I just need you to answer my question.
He said no.
Take it your answer is no.
He said no.
Okay, thank you. I have no further questions.
Mr. Hicks, do you have any questions for this witness?
Briefly, Your Honor, thank you. Good afternoon, Mr. Mack. How you doing? My name is Jesse Hicks. I'm with the town of Chestertown. Just real briefly, so your evaluation of the economics were strictly for Kent County.
That is correct, sir.
Okay, so you did no evaluation as to the economic benefits or detriments to Chestertown itself.
No, because the data is reported, the lowest granularity that we have on those data from the Bureau of Labor Statistics or anybody else in the implant model is at a county level or municipal level. By municipality, I mean a city.
Okay, so I was gonna say that we call Chestertown a municipality, but
I understand, sir. I apologize.
is there what's the definition between a city and say Chestertown? I understand Chestertown's smaller than that, but what is your definition of municipality? Is it a population level?
It would be whether, like in Virginia, we have independent cities. In many states, cities are not independent. So it would be that geography as it's reported to the Bureau of Labor Statistics. So if that entity exists as a legal entity at a county or city level, it is reported up to the Bureau of Labor Statistics. Towns are not. They are part of the county data that is reported.
Okay, so get to the point, you can't ascertain any type of economic benefit or detriment to the town of Chestertown.
The economic benefit would be to the county as a whole. No, I cannot specifically identify what portion of that would be within the town.
Thank you. No further questions.
Mr. Mangum, if you turn to page 4 of your testimony, I just wanted to try and understand. At the top, you state that the project would provide an estimated annual economic impact to Kent County during its operations phase of approximately 2 full-time jobs, $90,522 in associated labor income, $464 in economic output. In addition, if the analysis is expanded to encompass the entire state of Maryland, those impacts increase, and then you provide what they increase to. Can you explain how the analysis might be expanded to encompass the entire state of Maryland?
Yes, Your Honor. Again, what the model is doing is looking at the dollars that will rain down in a study area. So if the study area is Kent County, is looking at the economic profile of Kent County to identify what are the receptors for those dollars in terms of service or goods providers there. If you extend that study area to encompass the entirety of the state of Maryland, obviously there are more places for those dollars to land. As a result, the multipliers that are associated with that expand with the size, typically expand with the size of the study area. So an analysis that was conducted on the state as a whole would show larger impacts. Did that answer your question?
Yes and no. The 2 full-time equivalent jobs, those are related to the project specifically, no?
No, ma'am. The direct employment from the project would be 1 FTE. So that would incorporate fractional employment that would be partly vegetative control, partly maintenance. And I think there was a third category that was involved in that. Those are fractional numbers in that 1 FTE. The second FTE in terms of the total impact would be purchases from the vegetative control company or the maintenance company that would likely land within Kent County. And those are also fractional employment that would comprise that second FTE.
Okay, so then what would the 5 full-time equivalent jobs be?
It would be the same thing again, just extended. The direct employment is again 1 employee because that's the employment within Kent County associated with the goods and services that are purchased as a result of, or with the service that's purchased as a result of the vegetative control and the maintenance. The 4 additional FTEs are then where those dollars rain down on the rest of the state and are also fractional employment that's summed to 5 or summed to 4 FTEs.
Okay, thank you. Mr. Bugelmans, any redirect?
I have no questions, Your Honor.
Any questions from council based on my questions? Seeing none. Okay, thank you, Mr. Mangum. You're excused.
Thank you, Your Honor.
Mr. Bugelmans, your next witness, please.
Thank you, Your Honor. Next, we will call Mr. Mark Williams. Please turn your video on, Mr. Williams.
Yes, sir.
Mr. Williams, can you please raise your right hand? Do you swear or affirm under the penalties of perjury the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Attestation, Mr. Bugelmans.
Thank you, Your Honor. I hereby attest that the witness is alone in a separate room and not in communication with any other individual.
Thank you. Please proceed.
Hello, Mr. Williams. Could you please state your full name and provide your business address?
Mark Williams, business address, Earth Data Incorporated, 131 Comet Drive, Central Maryland, 21617.
What is your company and title?
Earth Data Incorporated.
Thank you. Do you have before you a document entitled Direct Testimony of Mark A. Williams, dated August 2nd, 2019, consisting of 83 pages inclusive of attachments?
Yes, sir, I do.
Thank you. Your Honor, I would like to request that this document be marked for identification as applicant exhibit 22.
So marked.
Thank you, Your Honor. Mr. Williams, was this document prepared by you or under your supervision and control?
Yes, sir.
If I were to ask you the same questions today, would your answers be the same?
Yes.
Is your testimony true and correct to the best of your ability?
Yes.
Thank you, Mr. Williams. With that, Your Honor, I would request to move applicant exhibit 22 into evidence.
Any objections?
Yes, Your Honor. Chris Drummond on behalf of Kent Conservation and Preservation Alliance. My objection will be similar to those I made earlier today regarding the testimony of the witness whose expertise I challenged.
Okay, and like earlier today, because you didn't file a motion to exclude testimony, I'm not going to entertain excluding the entire document. What we'll need to do is go through and you can argue what portions you'd like stricken based on your argument.
And Your Honor, Mr. Yeager, for the record, I'd like to note an objection to preserve my rights to make argument at a later time in support of Mr. Drummond's position. Thank
So
you.
noted. Now, are you supporting his position or do you have your own objection?
I need to hear what Mr. Drummond has to say first.
Okay, but you tentatively object to this document or portions
I
thereof.
object to preserve the record because I may want to, based on what Mr. Drummond says, I may have further argument, and I would like to have the opportunity to make that argument at the appropriate time.
So noted. Mr. Drummond?
May I ask a few questions first?
I'd like you to point us to what portions of the testimony you'd like stricken first.
Well, it would begin on page 2 and frankly go to the end of it. Mr. Williams purports to evaluate the quality of the soils on the project site for farming and present data to assess the variability of published soil types and prime farmland ratings. Based upon that statement, he then proceeds to testify regarding the conditions of the soils on the site and how they do or do not meet the requirements for categorization as prime farmland. Mr. Williams reports that he holds a Bachelor's of Science degree in engineering from the University of Arkansas. I'm not aware that a bachelor's degree in engineering prepares someone to become an agronomist, soil scientist, and so on. So I don't know how it is that Mr. Williams may offer opinion testimony based upon that background.
Okay, I'm reading from there's 1 of his testimony where it says that he is the owner and chief technical expert of Earth Data. As that, he oversees the daily activities and project-specific work associated with detailed soils analysis and hydrogeology. One of Earth Data's areas of expertise is to characterize soils in detail relative to the full range of hydrogeologic characteristics in order to determine the feasibility of using the property for its intended purpose. The experts under my direction include soil scientists, geologists, hydrogeologists, environmental scientists, and licensed well drillers. Earth Data is regularly engaged in projects that require the collection and description of soil and sediment samples ranging from relatively shallow to depths approaching 2,000 feet, and is familiar with both USDA soil descriptions and generalized texture-based geologic descriptions. Then he says he holds a BS in engineering. So I guess from excuse me, I'm still speaking. From that entire description of his qualifications, I do not find that he is not qualified to give this testimony.
If I might, you've actually proved my point, that Mr. Williams acknowledges that he does not have the expertise, that he manages those who do. And if the applicant in this case wishes to present testimony and opinion testimony on top of that regarding whether or not the soils on this property qualify as prime agricultural soil, what it should have done is propped up the testimony of the soil scientists upon that Mr. Williams supervises.
I believe
not
that
the
Mr.
supervisor.
No, I believe that's what he's doing. He's presenting the study that was done
By
as the
those with the
supervisor.
expertise, with those with the expertise to perform the study, not Mr. Williams.
And I am finding that he can present that study and the findings based on his position.
It's somewhat like saying that the office manager in a doctor's office can testify as to what the doctors found because he
Not
or
at all,
she.
Mr. Drummond. That's not an analogy. He's the supervisor of these people. Do you remember the question Mr. Bugelman's asked him about whether the testimony was prepared by him or under his direction and supervision?
Of course I do, but that does not characterize, that is not a predicate or a predicate for his expertise. It could have easily called the soil scientist who did the study. So we would have someone with the proper knowledge that I could correctly or perhaps effectively cross-examine.
I find that he can present the study that was done and the data therein.
Maybe Mr. Yeager has a different view. I don't know.
I don't know. I'm just flabbergasted on that ruling because for this to carry any weight, you need the person that did the study, you know, the actual person with the expertise. Essentially, he's presenting somebody else's work. And that's not how it works here. You know, for this to have some meaning and for a cross-examination to be meaningful and effective, you need the person here that has the direct knowledge, not the head of the company who might, you know, supervise the person who supervises the person who did the work. You need the person who actually did the work. So Mr. Drummond is 100% right on this. If they want to, you know, it's not up to us to tell the applicant how to present their case. The applicant should be presenting witnesses with actual direct knowledge.
Mr. Yeager, you're starting to yell. Okay.
All right, I'm done.
Down with the tone. What we're going to do is we're going to proceed to the cross-examination. And if there are questions that this witness cannot answer, then I will reconsider your objection. Mr. Drummond, do you want to proceed with cross-examination?
Thank you, Your Honor. Okay, Mr. Williams. My name is Chris Drummond. I represent Kent Conservation and Preservation Alliance. And believe me, I wasn't taking a shot at your professionalism or your broad base of knowledge. I'm very familiar with Earth data, and you all do very fine work. Mr. Williams, you acknowledge that the National Resources Conservation Service has characterized 76.5% of the soils on this property as prime farmland.
That number sounds about correct to me, yes, sir.
That designation was made by NRCS, which I think at the time was called the Soil Conservation Districts, in 1978.
That's
correct.
Yes, sir. That's my understanding. Yes, sir.
And that survey, strike that. The classification of soils as either prime farmland or farmland of statewide importance or neither of the above was the result of examinations of properties and surveys of soils, which the NRCS was directed to do by the Department of Agriculture. Is that right? U.S. Department of Agriculture.
That's my understanding. Yes, sir.
That was the result of a legislation emanating from Congress. Correct?
I don't know the specific lineage of that, but I find that to be a reasonable assumption.
Mr. Williams, are you familiar with, I think you are because you referred to it in your testimony, Title VII, Section 657.5 of the Code of Federal Regulations, or CFR?
So could you point me to that specific page, please, sir?
Well, Mr. Williams, I'm almost positive it's in here. You quote from 7 CFR 657 in two different places when you explain the definition of prime farmland.
Yes, sir.
On page 3, lines 6 through 19. Thought that you actually referred to 7 CFR section 657 in here somewhere. But if not, let me ask you, are you familiar with it?
It doesn't come to mind immediately, no, sir.
Soil scientists that you rely upon be familiar with 7 CFR section 657.
I think that he would be more familiar with it directly than I am. Yes, sir.
Ask you this then, sir. Are you familiar with the NRCS handbook for assessing farmland, soils in farmlands?
I'm familiar with it to the extent that in the execution of this project, I did discuss that with our senior soil scientist and a staff geologist who performed field work.
What do you understand the use to be made of the NRCS Soil Survey Handbook?
Well, I understand that the use was to identify the prime farmland and lands of importance that you described earlier.
Williams, are you aware that the NRCS is the only agency authorized by federal regulation and federal statute to classify soils as prime or soils of statewide importance or neither?
Yes, sir, I am. And that's why, if I may, in our report, we were very careful to not specifically refute that characterization. What our report says is we assessed potential variability in soil and topsoil thickness and slope classes. We didn't say NRCS was wrong. We were assessing variability.
You make sure I'm clear. 76.5% of the soils on the property proposed for this solar project are prime soils.
That number sounds correct. Yes, sir.
Of the 23.5% balance, do you know the percentage that of soils that are soils of statewide importance?
Based on the initial NRCS 1978 data?
Yes.
I guess I'd have to look it up in our report. I don't know that number right off the top of my head. No, sir.
Are you, Mr. Williams, familiar with the approximately 15 criterion that must be applied to soils to determine in the NRCS Soils Survey Handbook, the 15 criterion that must be applied to determination of whether soils are prime, soils of statewide importance, or neither?
I'm not familiar with those 15 specific criteria. No, sir.
Honor,
And
I think we are at the point at which we must determine whether Mr. Williams can testify further.
If I may, we focused on topsoil thickness and slope as indicated in our report as key elements of that evaluation.
I think we're at the point where we have to question whether Mr. Williams can continue. I will represent the following. The NRCS Soil Survey Handbook was originally, or at least the version that I have, was published in 1994. It has been continually updated through November of 2017. I provided a copy of it to all council and to Your Honor today. Under section in the handbook, the handbook recites the criteria for classifying soil that is set forth in 7 CFR section 657.5. A2 of that federal regulation, which you'll find, what I submitted this morning on pages 3, 4, and 5. Approximately, I didn't count them all, 15 specific criteria that must be considered in determining whether soils qualify as prime, soils of statewide importance, or neither. The depth of the topsoil and I stand to be corrected here, but I do not see that the depth of topsoil is one such criterion.
If I could respond to this, Your Honor.
Give me a chance here.
I'm finished yet.
I'm still wondering what opinion in this testimony that you're trying to ask a question about.
Your Honor,
Your Honor, I hate to interrupt you. You're very, very low.
Sorry, I apologize. Okay, I'm trying to determine. I'll hear from you, Mr. Bugelmans, but I'm trying to determine from what Mr. Drummond has said so far, what portion of the testimony he's trying to get questions about that have to do with the document that he'd like to possibly introduce. I heard the witness say that they were careful to not dispute the finding with regard to prime agricultural land according to the NRCS soil survey map. And then after that, Mr. Drummond is asking about various things, but I still don't, I'm not sure what you're trying to get at. So I can't determine whether he can, you know, is there another person that can answer your question or not, because I'm not sure the relevance of your question.
Perhaps I should say that I'm not sure of the relevance of this testimony. If the testimony is offered not to challenge the classification of the soil as prime, and that's acknowledged, happy with that stipulation, and Mr. Williams is free to go.
Well, I'm not testifying. I was trying to reiterate what I heard. I know then the witness went on to say that they did some soil borings. I do see where he says that I guess some of the results of the soil borings conflict with the prime farmland classification. And okay, I'm now on page 8, and I see what you're probably objecting to. He doesn't believe that it's accurate, that based on the results and data in the report, the USDA NRCS designation of 76.5% of the soil on the site as prime farmland is accurate. Is that what you have?
Yeah, I mean, that it could go from page 2 to page 8, and it's all leading up to that conclusion.
Okay, and you're questioning the ability of this witness to make that conclusion because he's not aware of 15, I think it was, criteria in
Approximately 15.
CFR. And you think another witness who may or may not be familiar with those criteria is the proper person to give this testimony?
He testified that the soil scientists would very likely be familiar with 7 CFR 657 and 657.5.
Right. I mean,
That's where these criteria are.
But, well, you don't have a witness to help us understand why what was done and what this witness can testify to is not relevant.
I'm getting it through him. I mean, but I can't get it through him because he's not familiar with these regulations. And therefore, he's not the right witness.
But, Mr. Williams?
Yes, ma'am.
Do you know if these regulations that Mr. Drummond would like to speak of are relevant to the analysis that was done by your soil scientist?
Do I know if the regulations are relevant? Yes, Your Honor, I do believe they're relevant. And again, if I may, the intent of our work was to assess variability, and the criteria that we looked at was the thickness of the topsoil, the slope, and then the some chemical characteristics, some soil samples that were collected, and with the intention of offering an opinion about the economic viability as you know, in 2019, was it viable as prime farmland? And so it wasn't to refute or dispute anything NRCS said or did. It was to look at it based on those specific criteria that we identified in our report.
Okay. Mr. Bugelmans?
Yes, Your Honor.
Do you know if your client is able to make another witness available who could answer Mr. Drummond's more specific questions?
Well, Your Honor, I think one place to start would be if Mr. Drummond could ask Mr. Williams the questions he intends to ask to see if Mr. Williams can answer them. I think respectfully, Mr. Drummond has mischaracterized Mr. Williams' testimony. You know, he's not refuting the prime farmland classification. He's simply doing additional analysis with his team, looking at additional factors that suggest this is not I'm sorry, Your Honor.
I'm going to stop you right there.
Yes.
Question on page 8. Based on the results and data in the report, in your opinion, is the USDA NRCS designation of 76.5% of the soil on the site as prime farmland accurate? Answer, no, I do not believe it is accurate. Do you see why I stopped you? I understand they went on to do a different type of analysis, but he does dispute the accuracy of the 76.5%. So unless he's going to withdraw that or change that testimony, I think Mr. Drummond would like to speak with someone who has more information about why that's inaccurate. Whether it's correct, whether that opinion of accuracy holds up based on a regulation that that person is familiar with, that Mr. Williams is not.
Is it possible for me to ask Mr. Williams some clarifying questions about that to try to see what he thought he was responding to with this, and then perhaps we could clarify his testimony? I see what you're saying, but I don't think that's really consistent with the majority of what is going on in his testimony.
It does sound as though there is, I don't know if I would call it a clarification. I think his testimony might need to be revised slightly, but I'm willing to have that be done orally.
Okay.
If you want to proceed that way.
Thank you, Your Honor. Mr. Williams, what?
I say, for the record, I object to that. It's my understanding. I'm going to repeat myself again. I thought that we were stuck with the written testimony that was submitted by the deadlines imposed by Your Honor. And
I think you have a misunderstanding of when I directed you to a testimony, Mr. Drummond, it was so that you properly referred witnesses to their testimony before you quoted it to them and asked them a question. That's different from the witness clarifying or correcting his testimony on the record today. We're trying to get the record correct. I'm not going to disallow it in the interest of getting the record correct. He can correct his testimony. And if that makes him, lose credibility as a witness, you are going to be able to argue that in your post-hearing brief. Do you understand? Please proceed, Mr.
Your
Buglemans.
Honor, I have a question, Your Honor.
I'm sorry, Mr. Yeager?
I have a question. You had mentioned bringing another witness, and my understanding was, as far as witnesses go, we are locked in to the witnesses that submitted written testimony. So my question is Your Honor planning on allowing additional witnesses in who have not already submitted written testimony?
No, that is not my plan. I was trying to find a way to appease Mr. Drummond in this particular discrete area.
I don't need to be appeased, Your Honor. It's perfectly okay.
Okay, Mr. Buglemans, do you understand what we're trying to do here?
I think I do, Your Honor.
Okay, please proceed.
Mr. Williams, are you disputing the NRCS classification for this site?
No.
What's the purpose of your analysis?
Purpose of the analysis was to check for variability in topsoil thickness and slope across the site, and make offer an opinion about the economic viability of the site, and compare those current data with the initial NRCS determination.
Are those conclusions dependent on the NRCS criteria for prime farmland?
Could you, you broke up a little bit. Could you repeat your question, please?
I'm sorry. Are your conclusions dependent on the NRCS criteria for prime farmland?
Are they dependent on the criteria? I'm not sure I specifically understand, but I think the answer to your question is no. What we did was, again, we looked at topsoil thickness, we looked at slope, we looked at the soil samples were collected, and we compared how many acres were had certain topsoil thicknesses and certain slope percentages, compared those to what was originally presented by NRCS, and determined that there were based on our analysis, we determined there were fewer acres of prime land on this particular parcel.
And by prime land,
I move to strike that because now he is opining on whether
Yep.
there are 76.5% of the acreage is prime farmland or not. He just said they concluded that some of it's not.
I don't recall ever specifically saying it was. I said that's what the NRCS reports said. That's yes, sir.
I'm sorry, Your Honor, I think you're on mute.
My apologies. I'm not going to strike that testimony. Go ahead, Mr. Bugelmans.
Are you prepared today to talk about or to testify on the basis for your conclusions in your testimony with respect to the viability of this site for agriculture?
Yes.
Okay, I have no further questions, Your Honor. I think it's clear what his testimony is doing. I understand Mr. Drummond's point on that, but I think it's clear from the body of this testimony that that's not what Mr. Williams is doing. He is looking at specific factors related to the soil on this site and is explaining why, in his professional opinion, this makes this not an ideal site for agriculture. I think if we want to limit his testimony to that, that is entirely appropriate. But I don't see a basis to completely exclude his testimony here. I don't think that that's sustainable.
Okay. I guess the sticking point I see is the question on page 8. So,
Your Honor, if I might also point out that if you look at page 2, lines 16 through 21, Mr. Bugelmans asked, I'm quite sure Mr. Bugelmans prepared this testimony, probably both the questions and the answers.
that's not really necessary, Mr. Drummond. Mr. Drummond?
Okay.
That's not necessary.
What is the purpose of the report? You can read Mr. Williams' answer. It has nothing to do with the economic viability of this farm. Moreover, I haven't heard that Mr. Williams, he may be many things, but he's not been proffered as somehow an expert in, profitability of farms.
Okay, I suspect that Mr. Bugelmans misspoke because I don't think that Mr. Williams is opining on economic viability. Specifically, he's sponsoring all portions of the report except for the economic viability analysis. So your objection would be correct, except I think Mr. Bugelmans was incorrect. I think that what we have here, if I could finish, back to page 8. Mr. Bugelmans, help me out here. I think if we strike the question starting on line 7, through the answer on line 10, no, I do not believe it is accurate. Can we pick up then with the data establishes that the majority of the soil on the project site is poor quality and not suited to sustain profitable farming operations? No, not wild about that either. Okay, we're going to strike through 11. But I think we can pick up back on line 12. Do you have a problem with me getting rid of your question and leaving the testimony, Mr. Bugelmans?
Sorry, I'm just scanning through this. I think that's appropriate, Your Honor.
Okay. And I think also Mr. Drummond, as well as other interveners, are going to have the opportunity to argue the value of this testimony based on what Mr. Williams did and didn't know, based on the CFR and its how it relates to all of this. You can certainly argue in post-hearing briefs that this testimony should not have any weight, but I'm not.
My concern is that if we've stricken the question, we should have stricken the entire answer, because now we have an answer that's not responsive to a question. So as I recall, Your Honor was striking the question and then striking part of the answer, but not the whole answer. That doesn't make sense. So I believe the only appropriate remedy here is if you're striking the question, you got to strike the whole answer, which would be, we would strike from line 7 all the way through line 5 on page 9.
No, I'm not going to do that. If you go up to the question before that, what is the significance of this data? I'm going to consider the rest of his answer starting on line 12 to be part of that answer to that question. Okay, I'm going to strike lines 7 through 11. But Mr. Yeager, I will hear from you. You noted an objection if you want to be heard now.
I have nothing further to add beyond what Mr. Drummond has stated and what I previously stated.
Okay, and as I said, the same applies to you. You can certainly argue in your post-hearing brief, of which we have one in this case, that as to the value of this testimony. But other than lines 7 through 11 on page 8, Exhibit 22 is admitted into the record. I have no questions for this witness. Any more cross-examination? I'm sorry, what was that?
Sorry, Your Honor. Let me. Mr. Williams. On page 5 of your report, you, or I should say, perhaps you and your colleagues conclude, after doing the testing, concluded that the average pH of the soil on the property was 5.65. Do you see that?
Yes, sir.
That puts the soil on the acidic side of the scale.
Yes, sir.
And that is, in your judgment, problematic for the productivity of the soil?
Yes, sir. Our report states what we concluded was that for optimal operations, that soil pH near to neutral was better. Yes, sir.
Does it surprise you, Mr. Williams, to learn that 7 CFR 657.5 A2 C Roman 3 says as follows? This is for purposes of classifying soil as prime or not. The soils have a pH between 4.5 and 8.4. Does that surprise you?
No, it doesn't. It doesn't surprise me. I saw this document earlier today and I read that.
Our finding of an average pH of 5.65 is well within the parameters of the Natural Resource Conservation Service for classification of soils as prime.
And we go on to say that low pH, some of the micronutrients tend to be more soluble. And so there's an explanation for some of that, sir. But what we say consistently is that neutral is better.
Of course. That's true of a lot of things, swimming pools, all kinds of different things. Do you know the permeability rate on average of the soils on this property?
I do not know, sir.
Would that have some bearing on the solubility of the acid or alkaline in the soil, the permeability of the soil?
Permeability would be a factor in that. Yes, sir.
Don't know the permeability rate of this soil.
We didn't test it. No, sir, we did not. So I don't know that.
What's the significance then of saying that the average pH is 5.65 if you don't know the permeability of the soil?
Well, because
it's a data point it's a data point that means nothing.
Well, in our opinion, it's a data point that reflects the average pH of the 16 samples that were collected across that site. And so I don't know if it means nothing. It's an average of 16 data points.
Williams, do you agree with me that even prime farmland needs to be managed? That is to say, you need compounds, chemicals, whatever, to manage, for example, pH levels?
I would agree that management practices would favor any parcel.
And that would include the introduction of organic material enhancements?
I'm not a farmer and I can't speak to that specifically, but yeah.
About organic matter amendments and enhancements?
So ask your question again, please, sir.
I think it was in the context of managing prime soils, and you indicated that management's important, and you said that certainly management of pH balances can be done, and now I'm asking you whether you can manage, in fact, improve, or the concentration of organic matter in prime soils.
I believe that can be accomplished. Yes, sir.
Or do you know, or did you ask the Clarks whether they had engaged in any of the soil management programs or practices that we've just described?
No, sir.
Okay. In point of fact, the soil could have been left to deteriorate, perhaps in anticipation of this hearing today.
Is there a question?
I'm sorry, Your Honor. That's completely speculative.
Yeah.
If that's an objection, it's sustained.
I'll withdraw it. Did Mr. Williams, did your team determine where the seasonal water table is?
No, sir. Not that I recall.
Water table have something to do with the productivity of soil?
It can be related. Yes, sir.
Okay. Now, I understand from your testimony, it's on page 7, that through the use of aerial LiDAR, you and your team determined that there was about 35 acres on the property with slopes between 5 and 10%. All right?
Yes, sir. That's what the testimony says. Yes, sir.
And 8 acres have slopes between 10 and 40%.
Yes, sir.
And I take it that soils on slopes greater than 5% tend not to be as productive as those that are on slopes of 5% or less. Is that about right? Is that sort of what you concluded?
Yeah, yes, sir. Thin layers of topsoil and more slope are not good things.
Because of erosion,
Yes,
stormwater management problems.
erosion. Yes, sir.
Would those slopes in excess of 5% exist along the ridge on the property that goes from east to west on the to the north of Route 291?
Well, I think it's safe to say that there would be more sloping along the area where the ridge is. Yes, sir.
Testimony indicates that essentially 72% of the property has a topsoil thickness of at least 6.6 inches, and then 6.6 up to 11.4. That's on page 4 of your testimony. Correct? Bottom of page 4.
Yes, sir. I see that.
And I take it that you and your team believe that 6.6 inches of topsoil is problematic?
Well, what we believe is that thicker topsoil and shallower slopes are better.
Thicker than what?
Well, the thicker, the more topsoil that exists, the better it is to promote the farming operations.
4 inches is capable of producing 4 inches of topsoil produces crops. Maybe not as many as you might want or the farmer might want, but it produces crops, right?
I can't specifically answer that, sir.
Mr. Williams, is 8 inches sufficient in your estimation?
Well, I would think that that has something to do with, you know, what are you growing and what's the slope? There may be other factors that contribute to that, and so I'm not going to dial in on a specific thickness.
In other words, there's not much we can take away from your testimony at the bottom of page 4, other than, like all farmers, we wish the topsoil was deeper than it is.
Well, I think one thing you can take away is that we did 479 soil borings out there and very systematically established what the topsoil thickness is and across the parcel. And it was highly variable, and it wasn't as yeah, it was highly variable, and the slope was variable, and a little greater slope than indicated in the initial analysis that was done in 1978.
What those observations are worth, I thank you. I have no other questions.
Mr. Yeager, do you have any questions for this witness?
I have no questions.
Mr. Hicks,
No questions, Your Honor. Thank you.
any redirect, Mr. Begelmans?
I have no redirect, Your Honor, but I would like to be clear for the record that applicant Exhibit 22 has been moved into evidence subject to the section stricken by Your Honor. I don't know if I heard you accept it into evidence, so just wanted to clarify.
That's fine.
Clear that we object to the introduction of the exhibit, though I understand the court's rulings.
Yes, other than lines 7 through 11 on page 8, Exhibit 22 is entered into the record.
Thank you, Your Honor.
Okay, at this time, I'd like to take a 10-minute recess, then we'll come back. I'd still like to finish at 5, if that's possible. Mr. Begelmans, do you have an idea of how long Mr. Hall's testimony might take?
I think 50 minutes is reasonable, Your Honor. Again, it's dependent on the questions, but I think it's doable.
Okay, great. So we'll reconvene at 4:10. Thank you.
Thank you.
Your Honor, am I dismissed?
Oh, I'm sorry. Yes, Mr. Williams, thank you for your testimony. You're dismissed.
Thank you, ma'am.
Mr. Court Reporter, you're ready to go back on the record?
I'm ready to go. Let's go.
Great. Thank you. Mr. Buglemans, your witness. Mr. Buglemans, did you want to call Mr. Hall?
I'm sorry, Your Honor, I was on mute. I have a separate microphone that was muted. I'm sorry about that. Yes, Your Honor, I would like to call Mr. John Hall, who's up on our screen.
Yes, I see him. Mr. Hall,
Yes.
can you please raise your right hand? Do you swear or affirm under the penalties of perjury the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes.
Mr. Buglemans, attestation, please.
Thank you, Your Honor. I hereby attest that the witness is alone in a separate room and not in communication with any other individual.
Thank you. Please proceed.
Thank you, Your Honor. Hello, Mr. Hall. Can you please state your name and provide your business address?
It's John Edward Hall, and I live at 23315 Chestertown Road in Chestertown, Maryland.
And what is your company and title?
Basically, since I retired after 30 years with the University of Maryland, it's JEH Consulting, Inc.
Thank you. Do you have before you a document entitled Direct Testimony of John Hall dated August 2nd, 2019, consisting of 8 pages inclusive of attachments?
I do.
Thank you, Mr. Hall. Your Honor, I would request that this document be marked for identification as applicant exhibit 23.
So marked.
Thank you, Your Honor. Mr. Hall, was this document prepared by you or under your supervision and control?
Yes.
If I were to ask you the same questions today, would your answers be the same?
Yes.
Other than these corrections, or I'm sorry, reading the wrong script here. Is your testimony true and correct to the best of your ability?
Yes, and I think we made some slight revisions in the commodity prices of grains in 2021 versus 2019.
Okay, but with those updates, would your answers to these questions be the same today?
Yes.
And is your testimony true and correct to the best of your ability?
Yes.
Thank you. With that, Your Honor, I would request to move applicant exhibit 23 into evidence.
Any objections? Hearing no objection, applicant exhibit 23 is admitted into the record.
Thank you, and the witness is now available for cross-examination.
Okay. Mr. Drummond, do you have any questions for this witness?
Hello, my name is Chris Drummond. I represent Kent Conservation and Preservation Alliance. Can you hear me?
Yes.
Okay. Mr. Hall, I heard you to say that you worked for the University of Maryland for 30 years. That was with the University of Maryland Extension Service?
That's correct.
What is the Extension Service?
Extension Service is a mission of the land grant universities to work with area farmers to develop different improved farming practices. And in the case of this particular project,
I'm asking you what the Extension Service is.
Excuse me?
I asked you what the Extension Service was. I didn't ask you about this particular property.
The Extension Service is part of the land grant mission of the University of Maryland, and that service is to provide expertise to farmers in the local area.
Thank you. Mr. Hall, you're aware that, or are you aware that the Clark Farm, which is the subject of this proposed solar installation, is shown on the NRCS soils map as 76.5% prime farmland?
Do you know what that means?
I asked you if you're aware of that.
under the previous testimony, yes, I am.
Okay. Um, You also heard the testimony, and I assume you reviewed Earth Data's analysis of the depth of topsoil, with about 72% of the topsoil having a depth of at least 6.6 inches. Correct?
I heard that as well.
In your testimony, you mentioned that the organic matter concentrate or component of the soil is very low.
That is correct.
And as a 30-year alumnus of the University of Maryland Extension Service, you must be familiar with the Extension Service's recommendations regarding organic material enhancements to soil.
I am.
Do you know whether the owners or the tenants of the Clark Farm have engaged in any of the organic matter enhancements recommended by the University of Maryland Extension Service?
They have.
And when was the last time that you are aware that they engaged in that management practice?
Continually. I'm still active, and I heard Rob Clark's testimony this morning. He does follow no-till practices, and he also uses cover crop.
Those are the only manners in which organic matter may be enhanced in the soil?
Well, there's other ways, but the question is it sustainable as far as agriculture is concerned?
Hall, if you were listening this morning, you heard me ask Mr. Clark whether you had asked him or members of his family for the actual crop yields. Did you hear that testimony?
I have not asked Mr. Clark for any crop yields.
So you don't know whether your concerns about the low organic matter components or what you describe as shallow topsoil have actually manifested themselves in lower than expected crop yields. You don't know that.
I do not know that.
Mr. Hall, curiously on page 2, lines 19 and 20, you testify that you assume this farm, meaning the Clark Farm, is subject to droughts. You see that? You see that testimony, Mr. Hall? Would this be a drought peculiar to this 500-acre parcel, that somehow it's an acre of like a small pocket of drought, and all the ones around it are not equally subject to, quote, drought?
Mr. Hall, you became muted at some point. You need to unmute yourself.
So, sorry about that. I think a drought can occur, of course, with no rainfall, but with the low organic matter, there's very low moisture holding capacity. So any other soils like that, particularly the sandy soils we see at Rock Hall or anywhere else in Kent County, there's going to be subject to drought because of the low organic matter.
This is a problem that's sort of endemic to Kent County, or Kent County where there are sandy soils.
Kent County has a great variability of soil types, and that's just our history. And particularly along the water, they tend to be a lot worse.
That makes sense, doesn't it? That the closer you get to navigable water, the worse the soils tend to be.
There you go.
Right. So you would expect the soils, as you approach Morgan Creek, to be poorer than the soils further west on the Clark Farm.
Yes.
Okay.
And sometimes on the shore, it's the wetlands too around Millington that create some problems as far as farming is concerned.
Sure, but we're nowhere near Millington. Mr. Hall, is it also correct that the poorer soils, excuse me, tend to either not have been logged or are allowed to regenerate and become woodland?
It depends on the situation.
Well, I asked you if it's generally true that poor soils are either allowed to remain as woodland or regenerate as woodland because they're not very productive.
Probably that's a generalization we can accept.
And there is a significant extent of woodland on this property in the vicinity, or I should say on the eastern edge, more towards Morgan Creek. Is that right?
Correct.
Mr. Hall, you've heard earlier today that the Clark family has been tilling this property since at least not around 1954.
Yes.
I think that was about the date, which is a long time. It also happens to be the year I was born, so I know it was a long time. Yet you conclude your testimony by saying the land does not have the productive capacity to be sustainable. That's on page 4. You see that?
Correct.
Well, it's been sustainable enough for the Clarks for 67 years, Mr. Hall. Right?
Well, the big thing, Mr. Drummond, you obviously don't know the economics of agriculture.
Now that the Clarks are, I'm sorry.
What's really sad to say is the margins have been continually shrunk over the last several years. And that's why today the only sustainable agricultural land are those lands that can produce over 150 to 200 bushel per acre of yield. And that's why I said it's not sustainable.
But you didn't ask the Clarks whether they have produced 150 to 200 acres of bushels per 200 bushels per acre.
I did not. And what I did do though is go to a friend of mine that has about 10,000 database samples to reference what kind of soil fertility is with those different benchmarks. And that's what we were basing our results on.
Assume that you have interacted with the Clarks over the years in your role as the extension service agent. Is that true, Mr. Hall?
Yes.
So you know the Clarks.
I do.
So it wouldn't have been hard for you to get on the phone and say, can you give me your crop yields over the last 10 years?
It would have been very, very easy.
All right, but you didn't do that. Thank you very much. No other questions.
Mr. Yeager, do you have any questions for this witness?
I have no questions.
Mr. Hicks, do you have any questions for this witness?
Based on Mr. Drummond's questions there, no, I don't.
Any redirect?
No redirect, Your Honor.
Okay. Thank you. You are excused, Mr. Hall. Okay. The next witness I see is Mr. Bauer, and I suspect Mr. Bauer is going to take a significant amount of time, Mr. Bugelmans.
I think it's possible, Your Honor, although again, I don't know. He does have 3 sets of testimony. He sponsors a lot of the ERD, so it is possible.
Well, we can get started if you don't object to stopping and starting again tomorrow?
I don't object, Your Honor.
Okay, then let's get started.
Okay, with that, I would like to call as our next witness, Mr. Dane Bauer.
Mr. Bauer, can you please raise your right hand? Do you swear or affirm under the penalties of perjury the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Mr. Bugelman's attestation?
Sure, Your Honor. I hereby attest that the witness is alone in a separate room and is on a communication with any other individual.
Thank you. Please proceed.
Thank you, Your Honor. Hello, Mr. Bauer.
Hello.
Can you please state your name and provide your business address?
Dane Sherman Bauer. Our business address is 37534 Oliver Drive, Selbyville, Delaware, 19975.
And what is your company and title?
H&B Solutions.
And your title?
I'm an owner.
Thank you. Mr. Bauer, do you have before you a document entitled Direct Testimony of Danis Bauer dated August 2nd, 2019, consisting of 14 pages inclusive of attachments?
Yes.
Your Honor, I would like to request this document be marked as Applicant Exhibit 24.
So marked.
Thank you, Your Honor. Mr. Bauer, do you also have before you a document entitled Rebuttal Testimony of Danis Bauer dated March 20th, 2020, consisting of 4 pages inclusive of attachments?
Yes.
Thank you. Your Honor, I would like to request this document be marked as Applicant Exhibit 25.
So marked.
Thank you. And then finally, Mr. Bauer, do you have before you a document entitled Supplemental Direct Testimony of Danis Bauer dated October 20th, 2021, consisting of 10 pages?
Yes, I do.
Thank you. Mr. Bauer, Your Honor, I would like to request this document be marked as Applicant Exhibit 26.
So marked.
Thank you, Your Honor. Mr. Bauer, were these documents prepared by you or under your supervision and control?
Yes, they were.
Do you have any corrections to your testimony?
On one of them, I do. In preparing for the hearing, and on the document October 20th, 2021, I did an analysis of the greenhouse emissions using the AVERT model, which really predicts if you do a solar project, what the reductions would be in CO2. When I did that, I looked off of the tables from the AVERT model after putting in 45 megawatts and where it was in Maryland. And it clearly gave me the Maryland reductions. And I knew that Maryland imported 40% of its electricity, and I incorrectly took 40% of the PJM reduction, which was a grossly overstated computation. It turns out that of the PJM generation and reduction benefit, Maryland only imports 2.9% of the amount of electricity and the reduction that would be assigned to this project. So I adjusted it significantly lower.
Mr. Bauer, are you able to point to the exact lines of your testimony and state the corrected numbers?
Yes. Pull that up. So it was on page 6, line 17. I had stated that it was 25,172 tons, which I corrected to 1,912 tons. And then further down the same line, it reads 771,360 tons, which was for the 30-year reduction. And I corrected it to 57,382 tons.
Do you have any further corrections?
That was it.
Okay. Subject to these corrections, if I were to ask you these questions today, would your answers be the same?
Yes, sir.
With these corrections, is your testimony true and correct to the best of your ability?
Yes, they are.
Thank you. With that, Your Honor, I would request to move applicants exhibits 24, 25, and 26 into evidence.
Any objections?
Your Honor, Jesse Hicks here, just clarifying, because he only sponsors sections 1, 4.c through f, 5.a, 5.b.1, and 6, that those are the only sections being admitted because these are the ones that are sponsored by Mr. Bauer.
The applicant already moved the environmental review document into evidence at the beginning of this hearing.
My mistake. I apologize, Your Honor.
Yeah, that's exhibit 4.
Your
So
Honor,
this is just his testimony.
can I just ask Mr. Bauer, I didn't have his testimony in front of me, the correct one of his 3. Could you please repeat the corrected numbers? I guess that's on your, now I figured it's on your supplemental direct. Can you just do that one more time, please?
Sure. Go back to that page. So the correction should be on page 6, line 17. It had read 25,172 tons. And I corrected it to be 1,912.74 tons. Then when you multiply that number by 30 over a 30-year period, I had in there before 771,360. It should be significantly lower at 57,382.2.
Thank you.
Sure.
Any other objections to exhibits 24, 25, and 26 coming into the record? Okay. Hearing no objections, applicants' exhibits 24, 25, and 26 are entered into the record.
Thank you, Your Honor. And with that, the witness is now available for cross-examination.
Mr. Drummond, do you have any questions for this witness?
Bauer, my name's Chris Drummond. I represent Kent Conservation and Preservation Alliance. Hi, Mr. Drummond. How are you? Good. Mr. Bauer, I didn't notice in the environmental review document any analysis of the deposit of chemicals leaching from or otherwise falling from the solar panels and the structures that hold them up onto the soil over the next 30 years. Did you conduct any such analysis? No, our job is not to conduct any analysis. Our job is to oversee all the consultants who are preparing all the analysis and to take their results and to compile them into a report. Our review is to determine whether or not, based on the work they've done and our expert knowledge of the laws and regulations, whether we think there's a reasonable expectation that what they did addresses the environmental concern. Well, Mr. Bauer, is it an environmental concern that chemicals leaching from the plastic, the vinyl, the aluminum, the steel, and the concrete will be deposited upon the soils during the lifespan of these solar projects? To best of my knowledge, it will not. And the information it's not a concern, or it's not something it's not a concern. Let me qualify it though, because we're getting this information from the solar designers. We do 85% of the projects in Maryland. This has been the standard answer that we've gotten on all the solar panels and the answer that we've given to the Public Service Commission, which has been accepted on the other projects that we've done. So we had no reason to question it when that information came to us. Not aware of any studies of the composition of the soil once a solar project is removed, because would it be fair to me to assume that none have been removed so far and that testing has not been done?
Now, I have never seen a case where anybody has demonstrated for the projects in Maryland that this was a concern. So we did not raise it in the preparation of our ERD.
How do we know if it's being a concern if nobody's undertaken a study?
We rely on other experts.
Those experts would be the manufacturers of the
Yes.
components.
Yes, sir.
That's convenient, isn't it?
It's the information that the industry accepts.
The pharmaceutical industry accepted that synthetic opioids were not dangerous as well.
I'm sorry, Your Honor. This is
Sustained. Sustained.
Thank you.
To be clear, to your knowledge, no study has been undertaken anywhere to determine whether the components of a solar project.
Again, Your Honor, this is outside the
I haven't
scope.
finished yet.
Well, you've already asked the question. This is outside the scope of Mr. Bauer's testimony.
Wait a minute.
I'll allow him to finish his question, and then you can renew your objection.
You're not aware of any studies that have undertaken to determine whether the composition of the soil beneath the solar array is altered in any fashion during the life of the project?
I'll allow the question.
I would not be aware of it. Like I say, we determine how to respond to certain sections of the ERD based on experts on the team.
Our hold on. I got somebody here, John.
I'm sorry.
Can I call you?
That's no problem. No, I was in there.
I apologize, Your Honor.
I'll see you.
Okay. I apologize. Mr. Bauer, on page 5, your initial testimony, your direct testimony, you opine that you see no environmental reason why the site would not be once again available for agricultural use or residential development after decommissioning. Recall that?
Which document is it?
Direct testimony from August of 2019.
Which page is it?
5. Lines 18 and 19.
Yes.
All right. Did I read it accurately?
It says yes. That's correct. I see no environmental reason why the site would not be once again suitable for agriculture.
But what we don't know, and you've acknowledged that what we don't know, is whether the components of these facilities do have some sort of environmental impact on the soil over the course of their life.
I've already told you that I don't know of any, and I've been doing this for quite a while.
Page, Mr. Bauer. Lines 14 and 15, you indicate that after decommissioning is complete, or as part of the completion of decommissioning, that the site will be graded to original elevations. What grading will be done in connection with the installation of this project, Mr. Bauer?
Very little. same with all the other ones. You do a little bit of grading. I'm going to explain it to you. You do a little bit of grading at the entrance. You have to do some grading where you put the electrical pads in. You don't do any grid. This site is not going to be mass graded. This site doesn't need anything like that. It's not like Western Maryland. So they will put the panels right on the existing grades. It will not be graded. If we remove a couple of trees, they will be graded out so that it's level with the existing topo on either side. But I think in the ERD, we said that the actual impervious area that results from any movement of earth on this site is like less than 2%. There's very little earth disturbance on these projects.
Whatever is disturbed will be returned to the natural original drainage characteristics. Correct?
Yes. The reason I'm pausing is because we're going to do a lot of tree planting here. And sometimes the owner opts to keep some of these screening plantings in place. And if we widen an entrance, sometimes the owner wants the improvement to be left in place. But other than that, yes, all the other drainage characteristics should remain the same.
On page 3 of your testimony, somehow you say that on line 10, less land disturbance will result in lower runoff. Do I take that to mean that the land disturbance to which you refer would be tilling the property?
Well, you go through lots of land disturbance with farms. You go through planting periods, you go through tilling, you go through, although this is no till, you go through harvesting, you go through soil amendments. You won't have any of that with a solar project. It's required to be stabilized prior to going into operation in a forested similar condition based on stormwater requirements. So it'll be fully vegetated with no disturbance to that vegetated area during the life of the project.
Line 5, you referred to increased site environmental monitoring. First of all, increased over what?
Well, there's nothing going on out there now. Now they'll have their sediment and erosion controls will be monitored. Their stormwater systems will be monitored. There's various conditions from the Public Service Commission that we'll have to revisit the decommissioning plan. We'll have to satisfy a lot of requirements that are not currently affected to the way the site is being used right now.
I get that from your point of view, agricultural practices on farmland are about the worst use of the land.
It's the more disturbing use of the land.
Interesting. On page 5.
You broke up for a minute.
I'm sorry. On page 5, line 14. You suggested part of the decommissioning plan will be to ensure that there's 8 inches of topsoil left behind.
That's a standard condition in the decommissioning plans that are required by the Public Service Commission.
That's because 8 inches of topsoil is deemed appropriate for successful agricultural production.
I can't answer that question. All I can tell you is it's a condition of the standard decommissioning plans approved by the Public Service Commission.
I want you to learn that 8 inches of topsoil is about the average of the topsoil that presently exists on site.
I'm not an expert on that at all.
I don't have any other questions. Thank you.
Mr. Yeager. Mr. Hicks.
Thank you, Your Honor. Good afternoon, Mr. Bauer. My name is Jesse Hicks. I'm with the town of Chestertown. How are you?
Good. How are you?
I'm doing good. So I'm going to go through your report a little bit. On page 15, you indicate that the CPCN process encourages, I'm at the bottom, last paragraph, local participation. The applicant intends to promote this inclusive process as part of its design approach and to continue to incorporate community input to the extent practical. Can you go over how you've promoted an inclusive process for this project?
The client in the beginning, we haven't worked on this for 4 years, just so you know, so I'm going to go by recollection here. But when we wrote this, it was understood that they would be meeting with the county on multiple different levels in an attempt to reach some sort of compromise on the project relative to the bypass and a lot of other things that were of interest both to Chestertown and the county. I know that they also reached out to different property owners with regards to the vegetative screening and the project being located here and try to get input. Some of the environmental assessments that have been done here, just on my experience, I think I've been doing this for 6 or 7 years, have gone far beyond what a lot of the other projects have gone through. You can tell from the witnesses that you have here today. This is not typical. This has had much more attention, and the information has been provided at a number of different levels.
Well, hold on. You mentioned the witnesses testifying today. How many of those witnesses, besides the landowners, are local members of the community in Kent County or Chestertown?
I don't know.
Exactly.
I don't personally know these witnesses.
So you're referencing the witnesses being part of the inclusion process, but you can't say for sure what type of inclusion they've had with the local community.
No, I meant the information that they're providing is very useful to people who are interested in reviewing the project.
Okay. And something interesting you just said was you haven't worked on this project for 4 years. So you can't say for the past 4 years what type of inclusion there has been with the local community.
I cannot.
Okay. You have not participated in any type of local community inclusion, correct?
I have participated in whatever the processes were with the Public Service Commission. I have not participated in any local process.
And let me rephrase that. Besides last Thursday, because I did see you there at the public hearing.
I don't know if we probably had a site visit with PPRP, and there were a whole lot of people there during that visit, and they were exchanged. Go ahead.
Do you recall when that was?
It's been at least 2 or 3 years ago.
Okay, so we could safely say in 2 or 3 years, there really hasn't been any community involvement in this process.
I don't know.
I'm sorry, Your Honor. This is outside, again, it's outside the scope of his testimony. Mr. Bauer does not testify about the majority of the efforts made by the applicant to resolve local concerns. He's asking about things that Mr. Bauer was not involved with over multiple years. He's answered the question.
May I respond, Your Honor?
What I'd like you to do is restate the question.
Because it's noted in the environmental review that you sponsor, that the CPCN process is inclusive of local input. In the past 2 to 3 years, you have not participated in any in receiving or giving any local input in regards to this site.
No, sir.
Okay.
I have not.
Thank you. Not saying it hasn't been done, but as far as you know, that has not occurred in the last 2 to 3 years.
No, I didn't say that. I said I haven't participated, so I wouldn't know.
And that's exactly the point of my question. Thank you.
Right.
I'm going to jump to the end here. Just the end of your report. One of the things I note, Mr. Drummond got into the soil pollution during the course of the lease on the site, right? And you said that the information you receive is from the makers of the solar panels that said that there are no studies that show there is soil pollution.
not just from the manufacturers, but I said the solar designers who do this on a national level as well, and who have had to address these same kinds of questions with the Public Service Commission in the past. That's where my knowledge comes from.
But but I believe you said there was no studies that anybody could point to in regards to the soil.
No studies that I know of, although when you talk to the experts in the field, they will say that there have been studies done across the country.
But those studies are not part of the evidence here at this hearing.
Not to my knowledge.
Correct. And you don't have any knowledge of what is the substance of those opinions.
Well, Your Honor, I can answer it. Only these questions come up during the review of the application. They come up in the form of data requests. So I would say, since we are where we are and this project's been put on hold for an extensive period of time, I think a lot of those questions which get asked by PPRP have not really been distributed yet. And I don't remember if we had those questions on hazardous waste or impacts before we stopped working on this. I just don't remember.
Okay, so you have no knowledge of any hazardous impact on the soil during the course of the lease?
No, I don't.
Okay. One of the factors considered in is kind of what we're getting at, is the availability of means for the required timely disposal of waste produced by any generating station. And that's under the Public Utility Company Section 7207 E27. So we don't know about any of the, as far as your testimony today, about the hazardous waste of soil during the lease. Have there been any studies on the soil and the land after the lease has been completed?
It's not in my bailiwick, and I don't know of them.
Okay. As part of your environmental review document, you note that the land will revert, and this is the last page, 45 of 45, it's one paragraph, I think it's the last sentence. The land will revert back to its original condition, which could allow for eventual development for residential use based on market demand. You can't be certain that the soil will actually revert back to its original condition, can you?
Me personally?
Correct.
It wouldn't be my obligation, but I wouldn't know one way or the other. What I know is the applicant and his consultants and his contractors are required to meet that condition.
Are required to meet that condition, but it's in your environmental review documents. That's why I'm asking you. You can't say what that soil condition will be at the end of the lease.
No, I'm not an expert on that topic.
Correct. And the reason I'm asking you is because of you're the environmental review document, you're sponsoring it. Part of it is handling waste during decommission, right? Who is in charge of all of the waste that comes from decommissioning a solar farm? Specifically, because what we have solar panels, we have all the aluminum, we have the wires above 3 feet underground, we have the concrete slabs, we have all of these types of materials. Where does it go? What is the county responsible for recycling those, or for putting those into waste?
No.
Where do those go?
The decommissioning plan, and we prepare a lot of them, they specify that the applicant or the owner of the facility, because it could be somebody different at the time, the owner of the facility has to engage somebody to do the decommissioning. When they do the decommissioning, they have to develop a plan for decommissioning that's consistent with all the environmental regulations that are in effect at that time. It could be 30 years from now. So nobody can answer now how the disposal and recycling is going to be done in 15, 20, or 30 years from now. All we can do is lay out the objective of decommissioning and the fact that if they can, they should recycle. If not, they should dispose of it in a safe and environmentally responsible way. That's what the decommissioning plan says, and it's bonded. It's bonded by the state, and there's surety that's held in place, and it has to be updated every 5 years because the cost for these things is projected to change over time.
Okay. What are, obviously these could change. It's a 30-year lease. Obviously these could change. What are the decommissioning procedures right now? Let's say this was up and running and it's decommissioned. What would the procedures that would have to be followed? Are they just general, like you said?
Well, there's a logic to it. I mean, you take the panels off first, and then you take the posts out, and then you go underground 3 feet. You don't have to go further than that. The typical plans approved by PPRP only say that you have to remove things down to a depth of 3 feet. Then after you get all of the material out and you've disposed of it in a safe way, you have to come back and regrade the facility to as best you can to its original condition. If there's soil conditions in there, the contractor then has to do what he has to do to adjust the soil to meet the requirements that it's in the approved decommissioning plan.
Okay. So the decommissioning plan doesn't get specific until the end of the lease?
Now, if you read one of the plans that have been approved, it gives you like the 8 different components that have to be disposed of. But how they dispose of it, nobody could tell you now. Because the markets are going to be different, the environmental knowledge is going to be different, the state agencies that approve this could be all different. You're going to have to get sediment and erosion control approvals, you're going to have to get stormwater approvals. All these things are prospective. Nobody can know now and lock in now how it's going to be done at that time.
Right, and we have no idea how this farm will affect that land that it's on right now.
We don't know. Can you ask a question again?
Sitting, let's say, hypothetical, with this solar farm on that site.
Speak a little softer, you're a little too loud.
I'm yelling again. I apologize, Mr. Court Reporter. Hypothetically, if there was a solar farm on that site, we have no knowledge of what that solar farm is doing to the soil prior to decommission.
Well, when the state agencies approve this project, and if they approve it, the secretaries of each department have to sign off saying that this is consistent with all the state laws and regulations. So the assumption is when this thing gets approved and the conditions get established and issued by the Public Service Commission, if that happens, that there are no untoward consequences of the project, or it can't be approved.
What happens if it's not approved?
Then it's not approved.
And then the solar farm just stays there?
No, I thought you were saying if the project doesn't get approved.
I thought we were talking about
Saying that when they
decommissioning plan.
issue the CPCN, if they issue it, they can't do it, leaving something unaddressed. So if they issue the CPCN and the 7 secretaries sign off, it has to have met the test that the project meets all the state, federal, and local regulations, or it won't get approved to begin with.
To your knowledge, how many solar farms in Maryland have been decommissioned?
I don't know of any. It's too early. Well, I've only been in the business of doing this for 6 years, and that's when the vast majority of these projects have gone through the process and been approved. Nobody's even close to decommissioning anything.
We're talking about possibly one of the largest solar farms in Maryland going in at this Clark Farm, correct?
This is nowhere near the largest project in Maryland. Like I said, we do 85% of them. We got ones that are 100 and 200 megawatts.
Fine. One of the largest in Maryland, around 45 megawatts, excuse me.
I would say it's an average size facility at
Average
best.
size. It's safe to say that because none of these have been decommissioned, there's no way to say what the property, what the land will be, if it's even possible to revert it back to its original condition.
Based on the science that we know today and all the processes and the types of reviews and permits, we expect that the decommissioning plan that we're preparing, that's being reviewed by the agencies and approved by the Public Service Commission, that they are safe and adequate to do the job. I can't answer these questions any other way.
What is that science based on?
Today's science, the knowledge of these systems, how they're made, how they're installed, the kind of stormwater that we're going in, the kind of disruption that we're doing, the kind of metal that we're using. I mean, everything. It's based on today's knowledge and the expertise of all the review agencies.
But it's all speculation because we haven't had a single solar farm decommissioned in Maryland.
I would not say it's speculation. There's good science in Maryland. We're probably one of the best environmental states in the country. So I would not say anything that we're approving is speculation.
Is your review based on that science? Do you have that science somewhere in your review?
Well, the science is the knowledge of the different elements that have to be satisfied. If the industry says these things aren't hazardous, and the Public Service Commission has accepted that, we know stormwater, we know sediment and erosion, we know soils, we know how to restore them, we know how to chisel plow, everything that this decommissioning plan says, we know how to do and to manage.
Except it's never been put into practice.
Yeah, we're years ahead of having to. You're correct.
Working building. I apologize. I know we're running up against that 5 o'clock time. I just had a few more questions that I'm just looking for in my notes.
That's fine. We're actually past 5 o'clock. While you're looking, Mr. Bauer, were you planning to be with us tomorrow morning?
If I need to be.
Yeah, I hate to do this to you, but I did have a couple questions for you.
Okay.
So what I'm going to ask is, you'll go first tomorrow. Please don't speak with your attorneys about your testimony this evening.
Understood.
And you'll still be under oath when you show up tomorrow.
I understand. Thank you.
Thank you. Mr. Hicks.
Would you mind if I reserve till tomorrow too, Your Honor?
That's fine with me.
As long as there's no objection.
I'm hearing no objection.
Thank you, Your Honor.
Okay. And Mr. Yeager, did you not unmute quick enough to question this witness?
That's correct, Your Honor. We were having some difficulties unmuting, but Mr. Hicks covered the topics that I was going to cover if I had unmuted quicker and had the opportunity to cross. So I may have some questions based on questions of Your Honor, but at this time, Mr. Hicks has covered what I was going to ask the witness, so I do not have any cross-examination questions at this time. But thank you for checking in with me.
Okay, I understand you reserve your rights.
My voice is kind of out of kilter today too, so I apologize.
That's okay. We're hearing you fine. So yeah, Mr. Bauer, you're coming back tomorrow morning for Mr. Hicks's remaining questions, and if Mr. Yeager's decided he has questions, and then my questions, and then we'll do redirect and questions based on my questions. Okay, so yeah.
Yes, Your Honor.
You'll spend some time with us tomorrow. Do we have any, I did want to say, in looking at the rest of applicants' witnesses, I don't think that, and we still have PPRP's second witness, I don't anticipate that we will get to Kent County's witnesses or the town of Chestertown's witness tomorrow. So unless something strange happens, I think that they do not need to be with us tomorrow unless they want to be. Does that make sense? Any other housekeeping matters, Mr. Bugelmans?
No, Your Honor.
Okay. And you heard what I said to Mr. Bauer?
I did. We will have no communications with him.
Thank you.
Judge
Okay.
Lawrence, do we get another invite each day, or will we be able to click on the one from this morning?
You should be able to. I did the way I set it up, it's a continued hearing, so you should be able to click on the one link you received. If for some reason it doesn't work, I can send out a new link, but it should work.
You believe that we'll get to the PPR, I'm sorry, Kent Conservation witnesses tomorrow, so I should have two of them have been on today, but one is in Pennsylvania, and I would need to be sure that she's logs on tomorrow.
Yeah, I mean, I don't think we'll get to your witnesses, but I don't want to say we definitely won't. It would be late in the day.
Because two are local and they've been on all day, so we can go with them.
Okay, good. All right, so we will be in recess until 10 o'clock tomorrow morning. Thank you, everyone.
Thank you.
Thank you, Your Honor.
Thank you. Good night.
Off the record.
Thank you, Doug.